Good morning, everyone, and a very warm welcome to the speakers and the panelists of this national convention. A warm welcome to Team NCML and especially to the students and faculty of the Gujarat National Law University. This is the 9th edition, the 9th year of this convention. And trust me, this is amongst the most challenging for us, the organizers. Let me try to explain this to you. A few months back, the Honorable Supreme Court of India had delivered a judgment holding that the lawyers cannot be sued under the Consumer Protection Act. Incidentally, one of the judges on the bench went to the extent of referring an older case for review to a larger bench. This case, IMA versus VP Shanta, had held conclusively that the doctors are service providers and the patients are consumers. The reasoning for this review was that both lawyers and doctors are professionals. This statement led us to the question, if not consumer courts, what would be the alternatives available to patients? This question arose in the minds of all those who are connected with healthcare: doctors, hospitals, lawyers, policymakers, media, everyone. Hence, the choice of this topic for the National Convention on Medicine and Law 2024. But suddenly, last week, a larger bench of the Supreme Court held that there was no need to review the VP Shanta judgment. Many of our speakers and others thought that now this question has become redundant. And the reason for having this convention. Friends, in a democratic country like ours, law is always made by the will of the people, which is reflected in the legislature. More than 30 years have passed since the doctors were brought under the purview of the Consumer Protection Act. Demands have been raised by many regularly and vociferously to remove doctors from this Consumer Protection Act. This demand was, in fact, even acknowledged by the government, which made changes in the draft bill of 2019 by removing healthcare services from the ones that can be sued. Unfortunately, it got deleted again, and doctors and hospitals can still be sued even under the new Consumer Act of 2019. Therefore, this topic on which we intend to deliberate today was relevant yesterday, is relevant today, and will remain relevant tomorrow. We are attempting to find out if there are better ways of dealing with cases of medical negligence. Various countries across the globe have experimented with new ideas and new protocols. Is there something that we can learn from them? Is there something that we can imitate from them? Something that will be good for the overall healthcare system of this country. In a healthy and vibrant democracy, discussions and deliberations should never stop. No law is perfect, and there will always be room for improvement. As the Executive Director of the Institute of Medicine and Law, I sincerely thank the faculty and students of the Gujarat National Law University who have worked tirelessly in collecting and analyzing a few alternatives. I would especially like to mention two faculty members who have acted as the bridge between these two organizations, Dr. Dhania and Dr. Vidisha Joshi. Our special thanks to Justice Ravi Tripathi ji, who has very often taken time out from his very busy schedules to be part of many of our events, and to our almost permanent moderator, Dr. Parag Rindani, moderating a session with lawyers, doctors, member of parliament, the intelligentsia of the society, who very often take independent and opposing views, is really, really tough. I welcome and thank all the speakers and panelists and hope and pray that these deliberations will be useful for the society. Lastly, friends, let me repeat what I have been repeating for the last 10 years. This convention happens to be a starting point for us. With GNLU, we will bring out a white paper. We will engage with the policymakers and opinion formers and the other stakeholders in healthcare and all sections of the society to bring this to its logical conclusion. With these few words, I now invite our moderator for the day, Dr. Parag Rindani, to take over the proceedings of this convention. Let me briefly introduce Dr. Parag to you. Dr. Parag Rindani is the Group Chief Executive Officer of the Wockhardt Hospitals. He oversees the operations and the clinical functioning of all the Wockhardt hospitals located at Mumbai, Nagpur, and Rajkot. He is the principal assessor for NABH and is part of the program on implementation training as also accreditation and assessor training program at NABH. Over to you, Dr. Parag.
Well, good morning and thank you very much. It's a pleasure to be here. And at the very outset, I'd like to thank all the panelists. And it's a privilege and an honor to invite to deliver the inaugural address. First of all, I'd like to respectfully acknowledge the presence of Justice Ravi Tripathi sir here. Justice Ravi Tripathi sir, as most of you would know, he is a former judge of the High Court of Gujarat. He is a former member of the Law Commission of India and a former chairperson of the State Human Rights Commission, Gujarat. Justice Ravi Tripathi ji, it's an honor to have you here today once again. It's my honor to see you, and I'd like to invite you to kindly give the inaugural address, sir.
Bharat Mata ki Jai. Good morning to everybody. And I'm really happy and feel honored to have this opportunity to address all of you. This is a very good exercise. As Ravindra Bangal has rightly said, that this is about 10th year that we are continuing with this exercise. Friends, I don't know, there is some misunderstanding on the part of the general public and especially the doctors that judicial system is not very friendly to them. I'll take this opportunity once again to repeat and reiterate that my 16 years experience as a judge of the High Court, I have not come across any case wherein you can see that the court is adverse or, against the doctors. The difficulty is that these are the days of commercialization, and to great extent our medical services are also commercialized. The Gujarat newspapers are full of the scandal, you can say, which has taken place in Khyati hospitals, and number of angioplasty and angiography are done. I'm told about 121 or so, and about crores of rupees from PMJY are taken by them. Now, this may be one of the factors which gives such impression, but I can assure you that judges do have a very, deep honor for the medical profession. Because if you, rightly notice, there are only two professions which are considered to be noble on the globe over. One is the legal profession and the other is medical profession. I correct it by saying that medical profession is higher than the legal profession for the simple reason that immediate pain relief is given by the medical profession. Now, today's conference, which we are trying to, go ahead, is thinking about the alternative forum for the consumer forum. Now, normally what happens whenever you're thinking about any alternative thing, you have to first pinpoint that these are the drawbacks in the existing system, and then you have to try to find out whether they can be taken care of in the present system itself, or really you need a very different alternative system. You know, about the Indian judicial system, it is said that the delay is the main drawback or flaw in this particular system. And delay, is not something which is unavoidable. It can be taken care of. And first, a very important thing which we normally used to consider at the National Judicial Academy, Bhopal also, in our system, there is a branding of the cases to be delayed one right on the day of inception of the case. Now, that is never the case. And a very right example was given by the persons analyzing this particular part. They said that suppose a train starts from Delhi to go to Chennai. You can't say from first minute when it starts that it is delayed. You have to have the schedule that this is the time when the train is supposed to reach to Chennai or intervening stations. And if it does not reach to those stations at the time prescribed, then you can start saying that it is delayed. And it may happen that on the intervening stations it was late, but then it can recover and it can reaches the place of destination, that is Chennai, on the right time. Now, alternative system we do want to consider, there is no doubt about it. And it is always good for a socialized and civilized society to think about the alternatives, because you may find some more effective, more efficient alternative mechanism. So it is very good that we are doing. In fact, I participated in that pre-session also, where the students of GNLU worked very hard under the guidance of Dr. Dhanya. And it is really a commendable job which they have done. And I think that will also help our panelists while we are discussing about the alternative forum for this particular thing. But once again, I want to reiterate that I assure the doctors that, sir, unless there is a specific, factual aspect, the judicial system is not adverse to you. It is always there to help out the people. And it has been taking into consideration various factors. And that is why the standard of negligence is also considered to be little differently in the medical cases. They say that unless it is a gross negligence, which is beyond the, conception of the, layman or a normal reasonable man, it will not be branded as a negligence on the part of the doctor. Because when the matter of negligence, there is another fact which is also required to be there, and that is about the malafide. And I bow down to say that hardly you will find a doctor who will malafidely doing negligent work to, treat while treating his patient. So that way it is very important to know. And doctors have to be, one of course aspect is there, for which of course the system has to find out about the documentation part. In the pre-session also it was discussed that, sir, doctors do not have the time to go on making documentation while they are performing their professional duty. It's absolutely correct. But for that, some solution can be found out. And in the days of this technology, when computer and everything is there, possibly that can be taken care of. So I look forward for a very healthy discussion and very, fruitful discussion to suggest to the authorities about the alternative forum if we can come to any particular conclusion. So with this, my all good wishes to all of you. And I'll not take long because I also look forward to hear experts on the subject on this particular topic. Thank you very much. Jai Hind.
Thank you so much, Justice Tripathi, sir. We appreciate the thoughtful insights that you've given us today. As we understand from the medical side, we totally respect the fact that the judiciary is never negatively inclined towards medical professionals, except in those cases of extreme malafide intentions being proven. Thank you again for that vote of confidence. And like we have done during the COVID years and centuries before that, doctors will continue to serve society. I think what's very important is that, especially after cases like the AMD case, the burden of financial sort of pressure, which has increased on the medical profession, is something that we would also need to discuss and debate today. And that is adding to the cost of healthcare overall. On one hand, we have our Honorable Prime Minister trying to drive down cost. On the other hand, we have a litigious society coming out with a lot of these things. So with that, without further ado, I'd like to now invite our extremely knowledgeable faculty and students of the Gujarat National Law University to kindly present the presentations on some of the research that has happened. Over to you, GNLU.
Thank you, sir. Good morning, everyone. First of all, I would like to thank Institute of Medicine and Law, Ravindra Mangal sir and Vajpayee sir for considering GNLU for this collaboration. And also special thanks to Tripathi sir, Justice Tripathi sir for suggesting GNLU for this collaboration as well. And I'm sure that, as sir rightly said, we'll be working on a solution like which is going to be beneficial for both patients as well as the doctors. So students have done some research along with every team. There are 5 teams we have created. Every team is having the doctors as well as the GNLU students in the their team, research team. So I would, without taking much time, I'm sure that this platform, like this is a wonderful opportunity that has been given to our students also to be part of this multi-stakeholder program where they are part of a policy research, and I'm sure that they'll learn a lot today. So without taking much time, I would like to invite the Model 1, the first team, which consists of Ms. Suha, Ms. Bhavna, Dr. Ayushi, Dr. Alpita, and Dr. Kalpana. So they have come up with a solution which is on strengthening NMC, National Medical Commission. Suha, are you there?
Yes, ma'am, I am.
Suha, quickly you can present. The time is 3 minutes. Please,
Yes.
over to you.
Yes. Just let me just share my screen.
Yes, please.
Yeah. Is my screen visible?
Yes, it is perfectly visible. Please go ahead.
All right. All right. Good morning to everyone present here on a Sunday morning. Thank you so much for taking your time out to listen to our presentations. So, Model 1, we are working on recommendations to the current medical system in India based on our analysis of the NHS system of the UK. So, as you all probably know, NHS system is UK's publicly funded healthcare system, and it just provides free and standard healthcare to the population at a free cost or a low cost. So these are some of the recommendations that we have come to based on what we've seen from the NHS. One is the need for an improved and standardized standard treatment guidelines. So as of now, the National Commission for Clinical Establishment is the authority that is supposed to give standard treatment guidelines at a national level. But we also see that states are also giving their own standard treatment guidelines, because of which there's a lot of multiplicity, there's a lot of confusion, and there's also the standard guidelines are not tailored according to the level of healthcare. For example, what should a block level health center do in case of an emergency? What should a small hospital do? What should a super specialty hospital do? So these are some of the things that should be looked at when we're making standard treatment guidelines. So our recommendation is basically we're looking at strengthening the rule-making power of the National Council of Clinical Establishment. And we feel like the biggest way to do this is by moving health to the concurrent list. Because as of now, because it's a state list, the states have the right to legislate on health-related subjects, because of which we're not able to make a national level standardization. The moment we make a national level of standardization, we understand what the basic level of care is as stated in the Bolam test. So the doctors will also be able to know as to what they're supposed to do, and this will be standardized across the nation. So this will be a good way to go about it. So this is based on the never-end list of the NHS as well. So this is right. And the second one is establishments of mandates and education regarding documentation. From our discussion with multiple doctors, what we have found is that the documentation procedure in India is not as stringent as that in the NHS. Documentation is the basic of the procedure that the doctor is taking, is one of the basic ways to establish whether the doctor has actually taken the basic duty of has actually taken the basic duty of care or not. So what we're recommending is that we're basically recommending that there are mandated classes from an MBBS level about stringent documentation to ensure that the practice is imbibed from a formative level. And the second one is that we are also basically recommending for the National Council of Clinical Establishments itself to give a format for stringent documentation to be followed by doctors throughout the nation, again to create standardization. And we're also recommending that there are regular awareness programs to ensure that all professionals are aware of the same from a block level. The third is that we find that Indian hospitals are often flooded with patients, because of which the doctors might not necessarily have the time to, make the detailed documentation required. So what we're recommending is that we're also recommending for qualified nurses who have undergone documentation training, who are also present when the patient's medical issues are being addressed. We are recommending that they can also be delegated this task. The next recommendation that we have taken from the NHS system is their twofold complaint filing system. So the NHS basically has a twofold complaint filing system, which allows for an internal complaint facility and a formal complaint facility. An internal complaint facility involves raising a ticket regarding an inadequate standard of care to the hospital administration itself, which is followed by an apology or assurance or some minor action. This is for minor issues of negligence. For bigger issues of negligence, we are of course will of course have to take it to a formal level, which is why we are recommending that medical negligence tribunals be established in all Indian states, with a national medical tribunal which has appellate jurisdiction to the state tribunals. So this will allow for enabling of formal complaints of serious cases of medical negligence. Also, while ensuring that the judges are specialists and have the required knowledge for in regards to such technical cases. Medical cases are very technical, and of course you need a lot of specialized knowledge in that field. We're also recommending that the doctors who give their testimony, we're recommending that it has a higher persuasive value in the eyes of the judges. And we're also recommending that these doctors who are giving the testimony go through additional qualifications such as a PG diploma or something, to ensure that again they are also understanding what the law is requiring them to do. So that will also give some standardization in their opinions. The next one is an education of medical professions in mandated standard of care. Again, so one of the biggest issues that we have seen is that doctors, because of the difference in standard of cares across states, and because there's a national STG, there's a state STG, there are a lot of conflicts, and the doctors are not really might not necessarily be knowledgeable of the standard of care, especially in smaller medical institutions. So that's why we are recommending for a regular update of the standard treatment of guidelines, and also regular notifications or bulletins which basically simplify and teach the doctors as to what the new standard treatment guidelines are. So this will give some education. Is also enable better medical services provided to patients. The last one is enabling a patient-centric approach. At the end of the day, the job of the court is also to ensure that patients get the access to the best medical care possible, and that they do not suffer any harm, which is why we are recommending two bodies based on what is there in the NHS, which is a litigation body and a commissioning body. A litigation body is something that that works on mediation. So basically, in the UK, 98% of the medical negligence cases end at the mediation stage itself. So that will be a great way to reduce the burden on our judicial system, and it's also a very quick and cheaper way for the patients to also get the justice that they deserve. So that's something that we're suggesting, and we're also suggesting a commissioning body. As we already discussed, the medical field is a very technical field, and combining medical with another technical field, law, that's going to put a lot of patients who are not aware of both of these fields into a limbo, and it's going to cause a lot of confusion. A commissioning body is basically a body that will be providing legal aid, guidance, and support to the patient in their journey towards claim for damages. So these are all the recommendations that we have come to based on our analysis of the NHS model. Thank you for your time.
Thank you, Suha. So can we quickly go to the next presentation, or we need a deliberation here?
No, let's move on to the next presentation, please.
Okay, thank you, sir. So our next team had worked on the medical tribunal, that is the suggestion that they are giving, and which consists of Mr. Shamuel, Ms. Anam, Dr. Ankit, and Dr. Jitendra Jaswal. Shamuel, can you quickly start your presentation?
Yes, ma'am.
Samuel, can I request the teams to kindly adhere to the 3-minute timeline that your faculty, Dr. Dhania, has put?
Sure, sir. Sure.
Thank you so much.
Sure, sir. Medical malpractice in India remains a contentious issue, and reform is urgently needed to address the deficiencies in medical litigation, ensuring protection against. Can I reshare this slide? I think there's a problem with it.
Yes, you may.
Quickly do it.
Yes. Okay. So medical malpractice in India remains a contentious issue, and reform is urgently needed to address the deficiency in medical litigation, ensuring protection against harassment towards healthcare providers and fair compensation for genuine victims of negligence. So globally, different systems address medical litigation in varied ways. The US primarily relies on the tort-based liability system. The UK uses specialized tribunals, while the Nordic countries usually go for the no-fault compensation model. What are the possible strengths for establishing a medical tribunal in India? The strengths are faster resolution than traditional courts, enhanced focus on professional standards, ensures privacy and confidentiality, medical expertise and adjudication, and greater accessibility to the courts. What are the downsides or what are the challenges that persist in establishing such tribunals? There are limited resources in a country like India. There is a chance of a potential bias of a medical professional towards its peers. There are challenges in implementation and overload, and the problem of inconsistent standards across jurisdictions as health is a state subject. What are the opportunities that arise in the medical tribunal system? They are integration with preventive measures, a patient-centric resolution model, an informed medical opinion in decision making, and quick redressal. However, the possible threats that such kind of system presents to us is that the increased accessibility would increase in bogus or fraudulent claim filings. And the second is the uncertain impact this system will have on the overall healthcare costs of India. So, what are the recommendations? To address these considerations, a 3-tiered tribunal framework is proposed for streamlined and fairer malpractice case processing. The first forum is the State Medical Council, composed of the State Health Secretary, the State Health Commissioner, and the State Health Director. The District Medical Officer will conduct hearings and send the findings to the State Medical Council about the instances of malpractices. The role of the State Medical Council is to assess if a prima facie case of negligence exists, and if so, it will refer it to the Ethics and Medical Registration Board. The second forum is the Ethics and Medical Registration Board, which comprises of one representative from the State Bar Council, one from the IMA State Chapter, and one from Indian Council for Medical Research. This body will conduct hearing akin to traditional courts and then determine practitioner liability and award compensation. The third body is the final or the appellate body, that is the National Medical Council, with 2 representatives from the Supreme Court Bar Association, 2 from the IMA, and 1 from the Indian Council for Medical Research. And this commission's ruling would be final, and only questions of law can be appealed to the High Courts and the Supreme Court. Furthermore, additional protections to prevent any counterproductive consequences and to manage costs. Standardized caps on compensation for various injuries may also be implemented by the National Medical Council, which would be revised over time to help prevent the increase in malpractice premiums. Despite challenges, a tribunal framework represents a promising improvement over current mechanisms for addressing malpractice claims. Thank you.
Thank you, Shamul. Our next team consists of Ms. Ritika, Ms. Samyukta, Dr. Nalini Anand, Dr. Mukesh Vora, and Dr. Mahima Jain. They have done their work on no-fault compensation. Ritika,
Yes, ma'am.
can you quickly upload your slide and present?
Yes, ma'am. I will
Yes.
present. Ma'am, is my screen visible?
Yes, yes. Please proceed.
Just a minute.
Ritika, you may start.
Okay. Ma'am, can I start?
Yeah, please.
Okay. So, good morning, everyone. Today, I would like to present on the Model 3 of No Fault Compensation Scheme. This system has been implemented in countries like New Zealand, Denmark, Norway, Sweden, and even Finland, and it is like patient-centric model where individuals receive compensation for medical injuries without needing to prove negligence or fault. It shifts the focus from assigning the blame to ensuring that timely and fair support is provided to those who are affected, while this scheme is promising. The scheme has its strengths, weaknesses, and considerations for implementation in India. Um, so let me begin with its strengths. So, the scheme ensures quick compensation, relieving patients of the burden of prolonged litigation. It also promotes patient safety and cost efficiency by directing resources towards care and prevention rather than legal battles. Additionally, it reduces administrative burdens, streamlining processes and fostering a more patient-centric approach. It also like enhances the trust and satisfaction by emphasizing transparency and accountability. The scheme also promotes safety and learning within healthcare systems, encouraging open reporting of like errors to improve best practices. And its broad coverage ensures more patients are protected, making the healthcare system more accessible and equitable. However, like any system, it also has its weaknesses that must be addressed, like the increased potential and ease of claiming compensation can lead to higher volumes, um, raising cost systems. There's also the risk of moral hazard where frivolous claims may arise. Compensation limits in some models can leave the patients undercompensated, and particularly in like the severe medical cases. Additionally, challenges such as causation, complexity, and eligibility confusion can also slow down the process and frustrate the compensation claimants. Perhaps most critically, the scheme may reduce the healthcare provider accountability, as the inability to sue might lower vigilance and patient care. So to effectively implement such a scheme in India, we have provided the following recommendations. Like first, the scheme could be funded through government funding and employer contributions, ensuring sustainability without overburdening the patients. Second, while no fault compensation is the focus, we must integrate accountability mechanisms such as audits and performance tracking to maintain healthcare standards. Third, we also need an affordable and effective administrative system that leverages technology to simplify claim processing. Fourth, introducing error reporting systems will encourage like transparency and drive safety improvements in the healthcare system. Finally, launching pilot programs in selected regions of India can help assess feasibility and refine the scheme before this no fault compensation scheme is nationwide rollout. In conclusion, the no fault compensation scheme offers a very like transformative way to address medical injuries with like compensation and efficiency for the patients. And I think by like trying to adapt it to the Indian context, we can take a significant step towards improving healthcare outcomes while also ensuring justice and fairness for the patient. Thank you.
Thank you, Ritika. Our next model is tort reforms, which is done by Ms. Prahashita Samar, Dr. Dhiren Mehta, Dr. Preeti, and Dr. Akashan Patel. Prahashita and Samar, can I request you to please start the presentation?
Yes, ma'am. Sure. Good morning, esteemed panelists and fellow presenters. Today, my co-presenter and I will outline certain key tort reforms to improve the medical tort system in India. It is pertinent to note that these reforms aim to enhance and not replace the current system. The first reform is having a standardized compensation formula with a cap on non-economic damages. So current compensation varies due to judicial discretion, which creates unpredictability. While there is a general principle for calculating damages in personal injury cases, it is utilized in certain medical malpractice cases and not in others. Capping non-economic damages while leaving economic damages unrestricted can promote fairness as well as consistency. Non-economic damages are harder to quantify, and therefore a cap can reduce the unpredictability. The benefits include lower average claim sizes, more settlements, and fewer frivolous claims, as seen as the US states, which enacted such caps with a 19% reduction in non-economic damages payouts. However, there are concerns about Article 14 challenges and inadequate compensation for severe cases of medical negligence.
Now, proposal 2 is that shortening the time for filing cases. Currently, the Consumer Protection Act of 2019 sets a filing period of 2 years in Consumer Commission and 3 years in Civil Court. With a 400% increase in the medical litigation reported by NLSAU Bangalore in 2015, many claims lack merit, as noted by government panel in 2019 that only 15% of them are true. Shortening the limitation period, introducing a discovery rule, and implementing a continuous treatment rule should be done. Now, what it will give as it would lead to faster case resolution. It will lead to reduced backlogs and also lower legal costs. While some late discoveries may be affected, prompt filing preserve evidences and enhance efficiency. Now, moving to proposal number 3, that is insurance set-off. What is insurance set-off? In the US, the collateral source rule can lead to overcompensation by allowing plaintiff to receive both damages as well as insurance payout. Though India does not formally apply this, overcompensations can still happen. Therefore, the proposal include insurance benefit from damages to ensure fair compensation. This would lead to fair compensation, simple calculations, and as well as reduce legal costs. Also, it will protect healthcare providers from excessive liability. It will also foster fairness as well as efficiency in the system.
The last reform includes mandating a pre-filing affidavit with expert opinion to validate claims. So, along with the complaint of such medical malpractice. This step can filter out weak cases at the very outset of the case, and this prevents prolonged litigation and unnecessary appeals. However, such requirement could slow down consumer protection remedies by complicating the process and therefore would deter financially limited plaintiffs from pursuing the legitimate claims due to added costs. For this, we recommend a district panel of experts who would be giving such expert opinions, so to ensure accessibility to patients as well as impartiality towards doctors. So as to conclude, while these reforms pose some challenges that have to be addressed carefully, these reforms present an opportunity to foster transparency and fairness within the healthcare as well as legal sectors. Thank you.
Thank you, Prakashita and Samar. So last model, they did a work on in line with new Mexico model. So we have with us Mr. Slok, Mr. Tarun, Dr. Vignesh Patel, and Dr. Nilesh Tang. Slok, can I request you to make the presentation?
Yes, ma'am.
Yeah, please.
Very good morning, all of you. I will begin by introducing the New Mexico model. The medico-legal screening panels of the New Mexico models include the statute establishes the New Mexico Medical Review Commission, which after the 1st of July 2022 is empowered to only entertain review of claims brought against independent providers only. Selection of panel. The director of the Medical Review Commission causes the respondent independent providers, professional society, or association, and the State Bar Association to nominate 3 members each to sit in the panel. In cases where such a professional society or association doesn't exist, or where the respondent independent provider is not a member of it, the director of the Medical Review Commission causes the state licensing board to nominate 3 professionals of the respondent independent provider. The statute binds the panel to only deliberate on 2 issues, namely first, whether there is substantial evidence that the acts complained of occurred and that they constitute malpractice, and second, whether there is a reasonable medical probability that the patient was injured thereby. Expert testimony. In cases where the panel has found malpractice in the cases complained of, the panel, the director of the review commission, and the professional association concerned cooperate and help the complainant by identifying and recommending an appropriate expert who helps the complainant with their trial. The healthcare provider who is a defendant in a suit of medical malpractice in a court or a respondent before the Medical Review Commission can pay the complainant's medical care and related benefits without the judgment is pronounced, before the judgment is pronounced. This is not meant to be an out-of-court settlement between parties. The working mechanism of the New Mexico model is the Medical Review Commission, composed of lawyers and healthcare providers, decide the maintainability of suits of medical malpractices brought against private practitioner, which as a judicial opinion is not binding upon the parties. The statute provides for the maximum compensation which may be awarded to the aggrieved complainant. And how this will be applied in India is that a medical grievances commission can be introduced to decide matters of medical malpractices against all types of healthcare providers. Just like courts, individual panels may be created by the director of the commission for individual cases, composed in the same manner as the New Mexico Commission. Such commissions can be created as tribunals at district and state levels and be granted requisite pecuniary jurisdiction. The strengths of the New Mexico model are cases entertained by professional healthcare providers and lawyers will reduce cases which do not lead to convictions or unsuccessful lawsuits. Having a balanced panel of medical and legal professionals offers a fair and informed assessment of claims and thereby reduces defensive medicine. And lastly, a legislation intending to establish a medical grievances tribunals on the lines of the New Mexico legislation would also explicitly define the pecuniary jurisdiction of such tribunals and the damages which may be recovered. Maintaining an effective and unbiased committee system involves significant administrative effort and may lead to an administrative burden. Then there may be a perceived or real bias as healthcare professionals or attorneys on the panel could lean toward protecting their professional peers. Then third is possible limited expertise. A standard panel may not always have specialists suited to the nuances of every case, leading to potentially inaccurate assessments. And fourth, quorum of panels. Indian courts and tribunals do not prefer an even number of bench to adjudicate any case. Therefore, a panel based on the New Mexico Medical Review Commission would require to be either 5 or 7 and not 6. Opportunities. Improved healthcare standards. Regular vetting can highlight patterns of negligence, prompting improvements in healthcare school protocols and training. Second, setting a national collaboration between medical and legal fields. Regular interaction between legal and medical experts can foster mutual understanding and collaboration, strengthening the healthcare and legal sectors. Third, making professional healthcare community accountable to themselves. By bringing professionals to decide the matter, we make them accountable to their respective professional associations to their colleagues, and to the general public. And lastly, the threats while adapting the New Mexico model include challenges to patient rights, which means critics may argue that the model limits patients' access to justice, as cases may be prematurely dismissed without a trial. Committee composition disputes means finding an unbiased and suitably experienced committee may be challenging, and disagreements over its composition could hinder the process. Third, legal challenges. Plaintiffs or advocacy groups may file lawsuits against the model itself, claiming it impedes due process, especially if cases are frequently dismissed. And fourth, defining quantum of damages may be perceived as unjust. Usually, the quantum of damages in tort is not decided by the legislature, and it's left to the knowledge of the courts. If a legislation is introduced to establish medical grievances tribunals and decides the maximum recoverable damages for medical malpractices, complainants and right groups may perceive it to be ultra-wise to the long-standing common law practices in civil disputes. The recommendations which we have are: first, legislative amendments required. Is the first, we would need inclusive jurisdiction. Unlike the New Mexico Medical Review Commission, which from the 1st of July 2022 only reviewed cases against private practitioners and not hospitals, the Medical Review Commissions in India should include all types of healthcare providers under its ambit to bring about a meaningful change from the present system. Second, establishing medical grievances tribunals. Each district should have minimum one medical review commission which decides the issues of medical malpractice brought before it. There should be a second tier of the said tribunal at the state level, which will entertain appeals arising from the district commission. All appeals from the state level tier should be heard in the Supreme Court. Appointment and training of panel members. Expert panel should include qualified medical practitioners and legal experts who are well versed in medical jurisprudence. This involves training programs and a standardized selection process to ensure impartiality and high quality assessments. Allocation of resources. Legislative bodies would need to allocate sufficient funds to support the infrastructure, staffing, and operational costs of these panels. Judicial and regulatory support. Unlike the Medical Review Commission of New Mexico, which is not legally binding, the Commission in India should act as a tribunal and have the authority to allow such suit or reject it with a chance of appeal against such an order. That's it from our side. Thank you so much.
Thank you, Slok. So sorry for taking extra 8 minutes. Over to you, Dr. Parag.
Thank you very much. I think the 8 minutes are very, very important because I think you've managed to give us an extremely clear perspective of the potential for change. And the reason I put that note to you was just that we didn't want to sort of expand. I have very senior dignitaries here, and I just wanted to ensure that everybody gets their time. So thank you very much. We'll be doing 2 rounds of questions, ladies and gentlemen. And the first round, I would request you to restrict yourself to about 3 minutes each. And the second round may be about 2 minutes. And depending on time, then we'll see whether there's a chance for a rapid fire also. So I'll start with a very old friend and a senior medical professional, Dr. Gurbir Singh. Sir, I just wanted to understand your perspective on how do you believe the prospect of consumer litigation has impacted the way medical professionals approach patient care and medical decision making. Has there really been a change? Dr. Gurbir Singh, you all would know from our past NCMLs, he's a very senior medical professional, has commanded very senior positions in Fortis Healthcare. Dr. Gurbir Singh, over to you.
All right, Parag, the primary thing is that the present adversarial placement of doctor-patient situation needs addressing to enable harmony for the patient, the doctor, and society at large. I do agree that the fundamental thing, it is equally essential to note the protection of patients' rights. But that shall not be at the cost of professional integrity and autonomy. Now, failure in striking a delicate balance could lead to inexplicable, consequences. Wherever you go into the definition of deficiency, 2 words come in: law and contract. Whereas there are only a few provisions and no basic law. these are some specific terms are there of contract between patient and the doctor, care provider. Now, the other important thing is, since the matter falls within the domain of contract, there is no room for exemplary or nominal damages, which was also brought out very nicely in one of the presentations. Now, the tenets of the Act are to protect patient against failure of doctor, but not against other malefic forces. Doctors, they are giving a nuanced service that is not easily quantifiable. Their work involves high education, training, proficiency, and success depends upon many factors beyond their control. Whereas, now what I would like to put across is, a doctor found negligent need not pay for others. The tenets of the law should be within the canons of the medical treatment at that given point. Now, these are some of the views which I had from 30,000 on this subject and what I see on day-to-day basis. Over to you, Pra.
Well, thank you very much for that very, very crisp point of view. I'd now like to invite Dr. Krishendu Mukherjee. Dr. Krishendu Mukherjee is a consultant surgeon based out of Kolkata. He's an examiner for the Royal College of Surgeons of Edinburgh and a course convener for the postgraduate diploma in medical laws at the National University. Dr. Krishendu, your point of view, sir. What do you think is happening, and what specific reforms would you personally want to see, sir?
Thank you very much. Am I audible?
Yes, sir.
Okay, thank you very much. Just a small query. I mean, this was an excellent set of presentations under the leadership of Dr. Dhanya from GNLU. The last presentation, if I'm not mistaken, this is a Mexico model. It is not a New Mexico model. Or you can say this is the new or revised form of the Mexico model, because New Mexico is actually a state in the USA.
Correct.
Whatever. The Mexico model is something that we have quite a bit to learn from. You see, we talk of New Zealand, the Nordic countries, the British NHS. They are wealthy countries, and the heterogeneity of the society in these countries is not the same as ours. Now, what I can say, the time is very limited. We have 3 to 4 minutes. I served as a penal and ethical committee member of the State Medical Council, West Bengal Medical Council, for 6 years. Now, what we have seen, roughly 1/3 of the complaints that we get, just by reading the complaint and the first response of the doctors, you can make out that these are frivolous complaints. Then there is about 1/3 where, again, most likely they do not have merit, and we know that this is going to lose. In the last third, these are the real contentious cases and needs to be properly adjudicated. I strongly believe that the main problem with the medical profession being in the consumer courts is the delay in justice, the length of time it takes. And if you remember, I mean, I'm sure you're all experienced lawyers. Originally in 1991, after the VP Santha versus Indian Medical Association, where the guidelines were laid out for cases going to consumer court from the medical services, consumer courts were supposed to take up cases which are kind of res ipsa loquitur or straightforward cases of medical negligence. But that hasn't happened. You know, consumer courts take up cases which are extremely complicated. I personally feel the only way forward is to have a screening committee. Now, if you go to the NMC Act, the state medical councils act as the first point of call for lodging a complaint. Now, somebody living in Kuch Bihar has to come down to Kolkata to give depositions. But the initial screening in this age of computers, you know, it can be done through a portal. But this is my only main suggestion. The screening should be done by another state. because I have personally seen incidences of nepotism, favoritism, and political influence. And this happens on both sides. Sometimes doctors use this, sometimes the litigants use it. So a complaint coming in West Bengal, it need not be divulged before, but it should go to NCR or it should go to Maharashtra. Similarly, a complaint coming in Maharashtra through the portal for the screening should come to West Bengal. After screening, mediation should be brought in. If we can do a proper screening model followed by mediation, I think nearly 60 to 65%, nearly 2/3 of the load on the consumer courts and the mainstream judiciary will decrease. This is my only humble submission.
Dr. Krishendu, excellent surgical precision, if I may say, used appropriately. And I think even when we, as part of our NABH duties, when we look at peer reviews, we always look at whether the peer reviews were blinded. And I think this is an excellent suggestion. If you're able to blind and cross-pollinate them across specialists from other parts of the country, it might help. I think that's a brilliant suggestion. Duly noted, sir. I'm looking for Dr. Arulraj, sir, if he is on the call. I'm not able to see him. We'll come back to him. But I'd like to move now to another very, very senior professional, Dr. Jailal, sir. Good morning, sir.
Good morning. Good morning.
Dr. Jailal, let me just introduce you, sir. He's a professor and head of Department of Surgery at the Kanyakumari Government Medical College. He is the President General of the Commonwealth Medical Association UK and a former President of the Indian Medical Association. Sir, my question to you continues in the same. We doctors have been fighting for a long time for removal of this biased approach, so to speak. Things have been grossly have moved grossly. I wouldn't say it's because of the law, but things have moved grossly against doctors, not to mention the physical abuse, for which apparently now our own doctor colleagues have said that we don't need a different law, which has just come out yesterday. But let's leave that aside. That's probably another NCML waiting to happen. What do you feel should be the correct way to lead the country in this, and whether it needs correction at all? Dr. Jailal, sir.
Yeah, thank you very much for the wonderful initiative. I'm so much fascinated by the reports or the suggestions suggested by the young colleagues. Yes, indeed, we are in a position that we need to change this Consumer Protection Act and the way in which that doctors are getting penalized for the various issues and the doctors are getting attacked. There are various suggestions were put forth. Only when the original Consumer Protection Act was introduced, when doctors were inside, we were expecting that it will benefit the public and it will be the quick disposal of the cases will be there, and there will not be much agony for the doctors to spend quite a long time in that. But now, contrary to that belief that what is happening in the court, the consumer cases are prolonged for years and years together, and there is no end to that, as the cases are pending in a too much way in that cases, and the amount of the compensation which is being offered has been exorbitantly increased. So at this point of time, we need to look it back whether we really need this consumer protection case. Is it really benefited the intention for which it has been started? And the answer will be absolutely no. So that is mandatory that we need to look for an alternative to this. And one of the alternative which the Indian Medical Association was propagating is the medical tribunal, and a lot of inputs and a lot of suggestions are there to make it into the tribunal setup. But if this is not happening, at least that there must be an amendment should be brought into the Consumer Protection Act. One of the most important thing which we are now trying for the compensation of the capping the compensation, and the way in which the compensations are calculated is it is very, very unexpected in the natural justice. A patient who is coming to a doctor for treatment, the treatment charge which the doctor is going to put do not depend upon his income or his background. A person who is earning 1 lakh rupees is going to come to the doctor, and he is not going to give that is 10,000 rupees as a consultation fee, or neither the person who is a laborer is going to pay the same. And when this is going to be there, and the treatment which we are offering is going to be safe, and when the law says and under the law that everybody is equal, but when a complication occurs to a patient with that it is calculated on the basis of their income, basis of that of the setup, and exorbitantly without any cap, it is there. So the first change which we are now asking for is only the capping on based on the an equal capping for a particular type of disease, particular type of damage, and it should be worked out. Second thing is most of the time what we are now seeing in the consumer protection, the composition of the panel which is there is not having people with the medical knowledge or the people who are involved in the medical profession as a member, and many places, and we are not seeing that medical members are included. So that need to be expedited, and the member of the medical professional, the knowledge should be included in the panel before taking a decision, and whether there is a evidence is there to punish those doctors. And the third, the Lagoti judgment, which is always mandatorily, which is putting that the before the admitting the case, which needs to be get the board has to certify there is a prima facie evidence of mistake, and that is also now not being followed in many of the cases, and that also we will be insisting on that, and it should be included in that. The fourth one, which we are talking about, the screening, which my previous speaker has put forward. I do not agree on that. That is a screening committee of the case from the Tamil Nadu should be screened by some other state, and one should be that. And then that means we need to put that for everybody. The judge from the Tamil Nadu cannot sit in the case of the judging for the patients of the Tamil Nadu. Why should we only penalize the doctor community and say that it should be, and especially when the people are going to be on the border area, and there is a states and the three borders are there, and which state you are going to do that on? And if you are somebody is going to say that case is going to be seen by the some other state, and that in principle, I do not agree. I do not say that our doctors or even the society is going to locally influence. A person who is powerful can influence anywhere. He will do that mistake, whether it is somebody is going to review it from Andhra or Karnataka, that person can do that. And we will go by the normal, and it is good process to the screening. It should be at the place where that is being put. The district medical board or the state medical board or the district medical officers which has been designated should have putting it to the other state. Looking forward for a change, and we are looking forward to have ideally to a medical tribunal, and if not, at least there is a changes should be, amendment should be brought in the Consumer Protection Act. But overall, and it is our dream, it is our wish that doctors shall not be under the Consumer Protection Act.
Thank you very much, Professor Jailal. I just wanted to just bring a clarification, Dr. Mukherjee, that it is New Mexico, a state in the United States, which was being alluded to. And just so that the audience also is just updated about this. Quickly moving on, the other thing we probably might need to think of, Professor Jailal sir, is that maybe there needs to be what should I say, a patients also being brought under consumer court for misrepresentation. Today, under the PMJY, we have loads of people who come to our hospitals and in BMWs, sporting lots of tons of diamonds on their fingers and around their necks, and they still come under the PMJY. So, gross abuse of patient privileges, patient rights also happening. Let's not forget that. And somehow it's always the educated, erudite doctor who's at the receiving end. Despite NABH now mandating display of rates across the board, there is still this discrepancy. Thank you very much, sir, for that crisp opinion. Let me now move on and check if Dr. Wankhedkar, sir, is there, another veteran of not only healthcare management and support of the IMA, but also of NCML. I don't see Dr. Wankhedkar. So I'm going to move on quickly to my good friend and quote unquote, my state Vasi, Dr. Shivkumar Utture. Dr. Utture, good morning, sir. Dr. Utture is Vice President of Indian Medical Association, a former member of the National Medical Commission, and a former President of Maharashtra Medical Council. aptly qualified to contribute on this discussion. Dr. Ture, your point of view on what reforms specifically do you believe are required to make these cases of medical negligence truly meaningful and truly required to get compensated for as time goes on? Over to you, Dr. Ture.
Yeah, thank you, Parag, and thank you very much. And thanks for the whole committee for inviting me today to put my views forward. I think excellent presentation by all the five panelists. And many things have, the time has come for us as far as CPA is concerned to think out of the box, not exactly what is going on. We have seen that it has been an utter failure over the years. And it has, almost tied our hands as far as we clinicians are concerned of how we treat our patient. So we were always taught that the patient should be treated as per your clinical acumen. But with CPA coming, the investigative point has become much more important than just your clinical achievement. And this is something that I don't think is proper. Now, 2, 3 aspects I would like to just talk about. Number one is as far as the case is concerned. Let me tell you, that is not the end of that case. If if you read what has happened in that case, it is still open for IMA go, to court against this as per the whatever is there, because this DK Gandhi case was summarily dismissed. But at that time, our IMA counsel was also there, Advocate Bajaj, and he put forward that the original case was IMA versus VP Shanta, not the other way around. The court has accepted that, and the court in effect has said that if there is, you can put forward this case and it can be heard in an appropriate way as and when it comes. And we have taken this opportunity, and we are in the process of filing our new petition also as far as this case is concerned. Another aspect, I agree with Justice Tripathi sir. But what I don't agree in this judgment is that it says that the lawyers are in a unique position. I think we doctors are in a much more unique position, because when a mistake is created by a judiciary, there is a way. There is, first of all, there is a time for him to read the whole case, to study the whole case, to put forward the petition. And then there is, in future, there is a way that it can be appealed in the higher court also. Unlike that, spot decisions sometimes have to be taken, because majority of these litigations come where the ICU setup is there. Spot decisions have to be taken by the clinician. He does not have the time even to refer to his books or the past cases or anything. So somewhere we become much more unique, which has unfortunately has been ignored by the court whenever when they gave that judgment that why lawyers should be there and the doctors cannot be there in that. Having spoken now, only let me be very, very frank, since I have been in the council both at the national and state level. All these issues have come up because of the failure of these bodies. May it be the civil courts, I'm talking about non-CPA courts, the civil courts, may it be the councils, because it was perceived that proper judgments were not given, and it was time consuming. CPA came out of that. Of all these, another thing you have to accept in India, someone spoke about standardization of treatments and, Clinical Establishment Act. I think that was the first speaker who spoke about NMC strengthening. Uniqueness of India, unfortunately, as compared to all these Western countries, is we have two parallel institutions as far as health is concerned. One is the health sector or the health ministry at the state level I'm talking about, and the other is the education, medical education ministry, under which these councils are coming. So there are two parallel systems which are running over here. That should be, I think, just as in the national level or at the center, there is only one health ministry which looks after both, and that is where the most of the problems are lying. Second aspect, you have to accept that India being such a huge country, and at different states, at different local levels, the way to manage a case depends on where you are. So some case which I, sitting in Mumbai, may manage in a 5-star hospital will be completely different from way it can be managed in, say, in a small, in Gadchiroli or something like that, or a PHC center and all that. So it all depends on the facilities. So as far as standardization is concerned, all these things have to be taken into consideration, because you cannot put the same standard in Gadchiroli what you would say put a same standard in metropolis like Mumbai. That is there. Of all these which were spoken about, I think that New Mexico model comes to very much close to what we have been discussing and in IMA, because it talks about the screening panel, then it talks about the expert testimonies which are there, cap on compensation is there. With that, I would definitely like to add on the New Zealand, Denmark, Norway model of no fault compensation. See, today you have to see that in India, the patient goes to the state councils, goes to the CPA, may go to the civil courts, which I think rarely they are doing because of the time factor, and go to the criminal also. Then you have the Human Rights Commission also coming up. So there are multiple fora which he puts the complaint against the doctor. So is the doctor going to follow all these everywhere or do his clinical practice? You have to accept that also. So the no fault compensation, I think, is also should be added to the New Mexico model. See, we are in a unique position in India where we can screen all these different models from all over the world and try to pick up, as I say, cherry pick the best that would be suited for our environment. And if we can do that, and this is what I would also suggest to the NCML and Dr. Dhanya from GNLU, which I've been associated for a long time. I think you can come out with a white paper on that where we've taken all these. And see, because when we say doctors don't want to be in consumer protection, we have to give the court an alternative. And that is the importance, I think, of this whole talk that we are having with all the experts in the legal and the medical field also. An alternative is a must. We are not saying that doctors are not negligent. We agree that there is a negligence over there, but for that small, less than 1%, why the whole 100% community is suffering today? Defensive medicine. I have been working in a government hospital. I have been working in a corporate hospital. I know some decisions, even if government hospital doctors come under CPA, but definitely I have got some protection and I use my clinical acumen because the facilities may not be available that is available in a corporate hospital as far as investigation is concerned. And the patient's expenditure definitely exponentially goes on increasing. If I have to prove that what I clinically feel, that I'm a surgeon now. So if I feel this is an appendicitis, I remember we used to just palpate the abdomen, say this is appendicitis and take it for surgery. Today, I cannot do that with the era of consumer. So thank you very much. We require to definitely deliberate on all these things and come out, I think, with a white paper so that can be given to the ministry and the judiciary to be considered as far as alternative to the CPA is concerned. Thank you, Parag, and thank you, everybody.
Thank you so much, Dr. Teresa. I think you've hit the nail on the head on so many points. Primarily being the fact that the moment you become a litigious society, there is a larger focus on diagnostics. There is a larger focus on trying to prove things that normally would not have been taken. But let's also understand judges and lawyers. They also try to understand us in so many more ways. So they do accept what is called the standard of care, and if the standard of care has been satisfied duly, then accordingly we know judges and consumer court dignitaries who have essentially accepted that under the given circumstances the standard of care was delivered. So we'll move on, sir. Thank you very much, Dr. Teresa. I have the next person. I'm going to have sort of a twin question to you. Professor Suresh Baramat is a professor of psychiatry and the head of forensic psychiatry, head of a unit, head of telemedicine center and NIMHANS Digital Academy at the NIMHANS, which is the National Institute of Mental Health and Neurosciences. Professor Suresh, my question to you is twofold. One, what is your point of view on how we can get out of this complex situation? And two, as a professor of psychiatry, understanding the psyche of both the patient as well as the doctors. I'm going to give you a minute more, Professor Suresh, to speak. How do you think this is affecting the country on a psychological basis. Over to you, Professor Suresh.
Thank you for every person, including National Law School and the organization involved. But let me put it in a very succinct way, telling us why we are taking this discussion. First and the foremost is economical reason. Simple reason is defensive practice costs 25 to 30%. It's both in private and also public. If I go to a doctor, out of 100 rupees, 30 rupees will be used for defensive practice. It's unnecessary, maybe diagnosis, lab test, all those things. So imagine for India, we are at the central government, we spend around 60,000 crore. In that 30% goes for defensive practice, 20,000 crore. It's not small amount. In private practice, every patient who goes there, their 30% is gone. It's a calculation which has been well established in US. They say that they also lose for defensive practice. Now the question is, okay, the defensive practice is there. Why? It's because of multiple litigations. What is multiple litigations? A criminal is not punished for the same crime in multiple courts, but here for a doctor, he has to go to consumer court. He may be called in criminal case, FIR, State Medical Council, State Human Rights Commission, Child Commission, Women Commission, and they even directly can go to High Court under Article 227 or Supreme Court Article 32. Along with all these things, there are many other health legislation. Clinical Establishment Act, we have a quasi-judicial board and also board. Transplantation of Human Organ Act, we have a board. MTP Act, we have a board. Mental Health Care Act, we have a quasi-judicial board, Mental Health Review Board. They will summon for each admission. Drugs and Cosmetic Act, if the raid occurs to the hospital. Preconception and Prenatal Diagnostic Technique, we have a board. Allied Healthcare Act, we have a board and also commission. Surrogacy Act 2021 has a board again. Assisted Reproductive Technology Act 2021. The n number of health legislation and the n number of regulation, what will happen? The doctor will, before he touches a patient, he has to see under which law this patient can sue me. Unfortunately, I was looking up to, I did not give the idea of about this when the GNLU presented around 3 days back, our students, but wish they had spoken about this. This multiple litigation, unfortunately, doctors are becoming more and more defensive and they are worried. And why I did this medical law ethics, human rights law, and also PhD in law, for this reason only. This is becoming a big menace. Above all this, we have come up with the National Medical Commission Act 2019. Section 30, subsection 2 says that you can remove the license of the doctor and also give penalty. So when I saw this, I was slightly taken aback when it was introduced, but it is now a blessing in disguise at this point of time. Why I would like to make it is, now we are telling alternative. Why alternative? We have so many. See, lawyers are bound by one Bar Council Act and they are maintaining well. And we have State Medical Council, we have many other forums, and why don't we strengthen that? So in this regard, I would like to utilize National Medical Commission Act, and which says that clearly section 30, subsection 2 says that we can punish them also by penalty and also for the removing license. So we need to reduce the threat at this point of time for our doctors. Otherwise, let me tell you, it is today 30%. Tomorrow it is going to be the cost of litigation will be charged by the doctor to the patient. Already the insurance companies are charging. That is becoming a big menace, and also the insurance companies are now mushrooming like anything, say that the indemnity insurance, and everybody is taking, including the government doctor. Uttare sir also has mentioned, government doctor also taking the indemnity insurance. I have also taken 5 crore. Why? Because the government hospital may not fight the lawyer. The lawyer who is there, we may attend or may not attend. I have lost faith in the system, actually, if you let me put it across straightforward. Why? See, the lawyers do not want to come under the scrutiny. At the same time, judges do not want to come under the scrutiny, and they would like to say that, no, we don't want to be under their whatever, not digress from that. So we need to have a one-place litigation. One-place litigation, it can be licensing, it can be compensation. Asking a person to go for multiple places is a harassment. Nowadays, even the doctors have been sued in the Lokayukta. Especially in Karnataka, we have Lokayukta. They have been given complaint there also, and they are going there. So invariably, these multiple litigations is causing a major issue. That's about the doctor psyche. A. B, now the question comes is, what is happening at the PHC level? This is from the doctor's perspective. I spoke what our panelist moderator asked. Now moving to the patient's perspective, let me argue from the patient perspective. Let me put it across to you. At the wellness center, primary health care, the Healthcare is very pathetic. I've been working in National Institute of Mental Health and Neurosciences. I go for national program evaluation across the country. Some states are so pathetic, they have to travel 70 to 90 kilometers to go and get the PHC treatment. Even if the PHC is made, the doctors are not there. And there also, if you go there, defensive practice, anything slightly higher, he will not touch the patient. You have to take to the higher. And the patient has to, especially in Uttarakhand, the patient has to go from one end to another. It takes one day. And you have a very good system in Bangalore. We have very good system in Mumbai, Delhi. That means we have extraordinary healthcare. But at the same time, poor patients, nobody is there for poor patients. Again, the compensation we discussed, if a patient who is very rich dies, he gets in 12 crore rupees. Whereas a poor patient pays because he is unable to earn. So he will be, that means poor person's money compensation when he is given will be very minimal. So what will happen? Again, there is, when I go to the police and the police, again, the consumer court, it takes, even the consumer court, the court runs for maybe decades nowadays, forget about years. Then I am taking as a patient law into my hand. I'm beating the patient. I'm beating the doctor. I'm attacking the doctor because I've lost faith in the system. So we need to completely overhaul the system. It's not just capping the amount is not going to work. We have to look from both the perspective, and many state governments, again, the health is, again, I really appreciate the bringing the health into the concurrent list. The simple reason is recently the senior citizens, the PMJY said we will give free for all senior citizens, and some states outrightly rejected for their political pathetic reason. Was it required? I don't understand what they don't think about the political reason. But anyway, this kind of a system needs to be stopped. We need to invest in public health. And during COVID, we have come to know what kind of public health system we are having. We need to think from a village, last person in the last mile, what he thinks when his son or his child is ill. Unless we think from both the perspective, the doctor will play huge defensive practice, and the village patient who is sitting there has to sell his soul, sell his property, and go to a doctor who is in a district hospital or maybe in the private hospital. It's not going to improve. And these government institutions, especially being in a government, I'm telling you, though I'm in a national institute, it's very good, but looking at the other health system, public health system is very bad. If we don't do the complete overall system, overhauling the system, we are not going to make any difference by giving alternative. Today it's Consumer Protection Act. And again, tomorrow we come up with another, and bringing the change will take a lot of time. We have to reduce the litigation. How we can reduce the litigation, we have to think about that, so that even the 30% what we are spending has to be protected. Thank you one and all. And I'm extremely sorry if I have hurt somebody and some profession.
Not at all, Professor Suresh. I think that's the plus point of having an open forum, a national convention where everybody is free to speak their minds. I think a lot of change is required both in the medical education arena. Now we are probably starting to teach quality and sensitivity and compassion in healthcare. There's a change required on the litigation side. Also, in terms of, I welcome the former Chief Justice, ex-Chief Justice's vision in terms of reducing the number of holidays. I wish we could get that many holidays as doctors, but let's not go there. Let's just try and move on. And I have with me a very, very senior functionary in medical laws, a doctor himself. He has been teaching law. I invite Dr. T.M. Ravishankar, who is a faculty in medical laws at the Anna Institute of Management, Chennai, and then the SRMC and Research Institute, Chennai. Also a founder member of the Professional Protection Scheme of IMA Tamil Nadu. Dr. Ravishankar, you are a very, very respected member of the Indian Medical Association for decades. We've seen your name for so many years. We've heard you at the NCML for so many years. Your point of view on how we can look at improving, transitioning the system from the Consumer Protection Act, which occasionally is also called the, instead of COPRA, it's occasionally also called the COBRA, but that's on a lighter note. Dr. Ravishankar, over to you, sir.
Morning, and thank you for your nice introduction, and thank you to Ravi sir and Bajpai sir for inviting me and for this wonderful topic and the discussion which we had with the students of the Law University. First thing, let's see, Consumer Protection Act, when it was enacted, they said 90 days to do justice. I don't think any single case have ever been concluded in the 90 days or 90 hearings itself. So first thing, there is a failure on the part of the Consumer Protection Act itself, that it has never rendered justice within the 90 days. Now, after 3 decades, IMA versus Shanta is being asked to relook by another judge. Then do you mean to say that the initial judge was wrong and the present judge was right? This is where I would like to put forth the community. 20 years back, the treatment was different. 20 years later, the treatment is different. The patient keeps repeatedly coming and telling you the same complaint again and again, when the doctor would not have advised for a bypass or an angioplasty or even an angiogram. But then when the patient keeps coming and telling again and again, at one point of time, we have to respond to his symptoms, we have to respond to his call and try to do an investigation and do certain procedures which are likely going to give him the relief. There are quite a number of times the diagnostic tool has been a therapeutic tool. Because of the psychological aspect, I think Dr. Professor Suresh, as a psychiatrist, will be able to give more input on that aspect. Why are we always talking about patient-centric? The hospital has to be patient-centric. Why should not the legal fraternity be unbiased? There are people who presented a patient-centric approach for the litigations. Why should it not be an unbiased? It has to be unbiased. I am not the one who talks that the medical profession should be out of CPA. But what is the whole issue in the CPA and the medical community into it? Delay, delay, delay. The delay of 20 years or 25 years. Right from 2010, I have been talking about the medical tribunal. I do have submitted a paper in the Indian Medical Association. Beyond that stage, we could not go about it. Medical tribunal with an early justice is the only scope. Why are you having an administrative tribunal? You don't want to waste the IAS, IPS, IFS officers' knowledge and skill. You want to settle the issue earlier and make them go back to work and do the best of performance. But then the CPA delaying justice for so many years, you are trying to put a sword hanging on his head that he is going to be a defensive practitioner. If he is going to be a defensive practitioner, cost of medical treatment is going to go high because of his defensive practice. More often, he will do an investigation just to rule out that the patient doesn't suffer that ailment. Otherwise, he would have to face a court or he has to go to the court. That is very simple. The number of models that has been presented, Indian population is not fit for no-fault compensation. Every Dom, Hick and Harry will come. Every patient who comes to your hospital will be filing for a no-fault compensation, which is practically not possible. Mexican is almost a little bit similar, or it could be adopted with lot of changes, as Dr. Shivakumar Utre has told you. Since I am an advocate of medical tribunal, I will always be stuck with it. A medical tribunal, with an experts from the medical community, with an experts from the legal fraternity, give the time frame that only this number of judgments adjournments has to be there, and conclude the case at the earliest. And that is the only way that you can render justice earlier, both for the patient as well as for the medical community. If you are going to continue the case for years together, I have quoted a case which has went for nearly 14 years, a compensation of 1 lakh awarded at the state forum, which went for 14 years. After 14 years, what is the value of that 1 lakh? I do have presented a paper at JNLU last year on inflation and medical compensation. The fixed deposit rate that is being given for the patient is also unfair. I am talking on behalf of the patient side. At the same time, this volume of money cannot be paid by any hospital or doctor. After 14 years, the 1 lakh compensation, you try to evaluate the inflation after 14 years. What is the value of the money? And what is it, the principle of a Consumer Protection Act? You need a financial compensation for the loss that he has suffered. This is the general basis of a compensation. If you have to consider all these aspects, I'll come back again. I will only advocate a medical tribunal, an involvement of an active judge, involvement of the medical fraternity. Screening committee will not satisfy any patient. Any patient doesn't go only to one place. Every possible way they'll go. And if you're going to give a screening committee, you go dissatisfied and go to the next level of forum. I think medical tribunal time frame with all the people involved through the Consumer Protection Act. Another subdivision has to be a medical tribunal to try medical cases so that early justice for the patient and a fair justice for the medical community. Thank you for the opportunity.
Thank you so much, Dr. Ravi Shankar. I think we've kind of come to the end of the first round of discussion and hearing, quote unquote, if I may say, the aggrieved party, because we are trying to discuss changes that could happen with the potential option for patients seeking redressal for their medical grievances. I think we've got a fair idea. I think a lot of pertinent points have been made by all the esteemed dignitaries in terms of, one, whether any of these options would work for India, being such a populous country. Two, why is it that doctors have the opportunity to get quote unquote penalized at multiple levels under multiple acts? Three, what are the opportunities for improvement that they're there? And multiple such opportunities were discussed by all the eminent clinicians, the physicians, the administrators. I'd now like to move to the legal side, and let's understand what the lawyers have to contribute to this. I have the privilege of asking to speak next Advocate Mahendra Kumar Bajpai, who is an advocate of the Supreme Court of India and the Honorary Director of the Institute of Medicine and Law. And he is an authority on medical laws. I know for a fact that I reach out to him when I'm in a dilemma. Advocate Mahendra Kumar Bajpai, your point of view on where do you think this will go? Where do you think this should go? Over to you, Advocate Bajpai.
Yeah. Thank you, Parag. You said there were doctors and there were someone who opposes them. Where do you keep lawyers? I don't know. Because doctors as well as patients both are aggrieved by us. So anyway, to come down to the topic, post opening up of the economy, commercialization of healthcare was unavoidable. It happened. Law reacted and reacted in a way that was expected. With commercialization, certain ills were bound to come. Accountability of medical profession was required. And today we see the change, especially with the senior doctors and here the number of cases that were filed before doctors came under the Consumer Protection Act and after they came under the Protection Act. 3,000, 5,000% increase. And even if we go by the formula put forth by Dr. Mukherjee, 1/3 of the cases are serious cases. So there were cases which were going unreported. Accountability of profession, whether it is lawyer, doctor, chartered accountant, is required. So let us not lose sight of the fact that the patients have got an avenue to get their grievances redressed. But what has it resulted into? We are expecting medicine, something as critical as medicine, from a doctor who is feeling threatened. The trust deficit between patients and doctors. I'm a practicing lawyer, I know. Defensive medicine, Dr. Suresh Badamat said 30%. Is it good for a country like India? Good students are not joining medicine. The words of Dr. Uttare keep on ringing. He once shared with me that they are 7 siblings, all of them doctors. and even their spouses are doctors. And none of the children are joining medicine. So friends, there must be deliberations, serious deliberations. Is Consumer Protection Act working? Is it not working? And what are the alternatives? I will specifically comment on all the 5 options which were shared by the students of Gujarat National Law University. The NHS model, the no-fault compensation scheme, as of now, it is not possible to implement in India. As and when we have the universal health cover, these schemes, because they need public funding. But yes, there are certain aspects which the students have shared with us, which can lay foundation for a better grievance redressal system. As far as tort reform was concerned, I don't think the period of limitation 2 years in India is a big time. Cap on compensation again is a very debatable issue, because non-economic cap, which generally most of the states in US they have implemented it. It's only non-economic damages, and in India courts are not giving a big amount in non-economic damages. Where 12 crore was given, the non-economic damages was only 10 lakh rupees. Yes, but the insurance set-off can certainly be looked into, and pre-vetting by experts of all cases of medical negligence is one thing that is required in today's scenario. New Mexico model, obviously, vetting by 3 lawyers, 3 doctors is a good option. But I will go with what Dr. T.N. Ravishankar has said. And I have always been very supportive of his ideas of medical tribunal. That is one forum which really can do justice in the right way. My wish list: number 1, something that could bring in trust in the system, trust between the doctors and the patients, without compromising on professional accountability. It should not be expensive for doctors. It should not be expensive for patients. At the same time, whatever we suggest should not be a financial burden on the exchequer. Otherwise, it will not see the light of the day. 2 very good proposals or ideas. A never-end list from NHS, if we could bring it somewhere, and compulsory preventive measures. If we could somewhere bring it in the current system, it was going to help, and expert testimony should be made mandatory. Against this background, I have already shared that I do think medical tribunal happens to be one thing which can be a panacea, the best option for India. It should not be an extension of NMC. Rather, the way it was put forth, it was a type of an extension of NMC. No, it should be a tribunal, like a tribunal, a judicial body. One small idea which I would like to share here, and especially with doyens like T.N. Ravishankar and Dr. Utture. Dr. Utture has done something very innovative when he was there as the chairperson of the Maharashtra State Medical Council. For the non-legal persons, let me share that in civil proceedings, there are two types of orders in some cases. Something that is known as a preliminary decree and something that is known as a final decree. Let me illustrate it. A family goes before the court and they are talking about, I'll get this much share, I will get that much share. In the preliminary decree, the court decides that Mr. A, you will get 1/8, Mr. B, you will get 1/6, Mr. C, you will get 1/20th. This is the preliminary decree. And then based on the preliminary decree, a final decree is drawn where exactly who will get what is decided by the court. Why can't we have a system like this in medical negligence cases? Let us understand that medical negligence cases also give us an opportunity to know where exactly mistake has happened or where exactly there was a potential for mistake. And it needs to be undone. There could be a preliminary decree. Doctor has done something wrong, the hospital has done something wrong. Whatever compensation is required should be given. And after that, the doctor or the hospital is asked to train its staff, its procedures, its protocols in such a way that such mistakes are not repeated in future. So after the preliminary decree, if in that very case, the doctor has not taken proper consent, the court can say, fair enough, we are passing a preliminary decree, you give this much money to the patient as compensation. But thereafter, within a period of 6 months, you come before us with 10 consent forms properly written. Before I end, I do agree with what Justice Tripathi said, that medical tribunal may not be a clear alternative, but the proposals, the ideas which we have could be merged with the current law, with the current grievance redressal system. And the last request, under the mediation rules which have been drafted, or rather which have been notified under the Consumer Protection Act, mediation is compulsory except in certain situations. And one of these situations that happens to be exception is where a death or grievous injury has happened. There, the court need not refer the matters for mediation. I think at least this part of the legislation must be done away with. Simply because a death has happened, simply because there is a grievous injury, doctor should not be considered as negligent. Mediation must be tried even in those cases. Parag, that is all from my side. Thank you.
Thank you so much, Advocate Bajpai. Interesting that you spoke about that, because yesterday we were at a nursing conference where there was a question raised about what is the medico-legal liability for nurses. And that's something that never gets discussed because it's always, quote unquote, the doctor, the admitting physician. Also, given the huge shortage of nursing in the country, as in when we move on to the role of nurse practitioner, these are other challenges that the NCML will have to debate on as we move ahead. So thank you very much for that crisp quick note. I move over to Dr. Dhwani Mehta. Dr. Dhwani Mehta is co-founder and lead with the Center for Legal Policy, an independent think tank that does legal research to make better laws and improve governance for the public good. Her interests include public health governance, health regulation, medical law, and ethics. She has worked closely on legal and ethical issues specifically related to end-of-life care and has appeared in the Supreme Court on cases related to the withdrawal of life-sustaining treatment. Dr. Dhwani Mehta, over to you quickly for your point of view, ma'am.
Thank you so much, Dr. Rindani. Please excuse me. I'll have to keep my video off today. I'm a bit under the weather, and
that's perfectly okay, ma'am. It's your thoughts that count, ma'am. Please, over to you.
All right. All right, thank you. So I just wanted to once again appreciate and acknowledge the efforts of the students from GNLU. I mean, I think they've made a fantastic presentation and have given me a lot of food for thought as well. Um, just a couple of overarching points that I think we should keep in mind while thinking about this kind of major policy change. I think I'm happy to see that there's a lot of research data now on the actual effective functioning of consumer courts themselves, the kinds of cases that are being brought, the kinds of compensation that is being awarded, the time that is taken to dispose of them. And I think it's great that we are moving towards a more evidence-based method of policy making. While thinking about what an alternative to them could be, I really think that there is value and merit in drawing from the social sciences. I feel like we don't have enough studies or research on what is it that patients want when they are aggrieved by medical negligence cases. Because my suggestion here is that it may not in all cases be monetary compensation. I mean, monetary compensation is a placeholder for the kind of, it's a sort of substitute for, it's some form of acknowledgement of the harm that has occurred, but it may not always be what patients are hoping for. In many cases, they actually want apologies from doctors. They want an acknowledgement that they were wronged. They want the hospital to commit to taking certain kinds of action that will prevent this kind of situation from recurring and harming other patients. And I think the NHS does have some methods whereby systems like this, or different forms of redressal like this can be explored. So I think we need to start by understanding what is it that patients themselves want. What are the ways in which some of that harm can be redressed other than through a judicially determined finding of liability and quantification of compensation. And I think that in itself would be able to give us a lot of alternative answers to ways in which to resolve these disputes. The second is, and the second overarching point is actually identifying and defining medical negligence a bit more narrowly. For example, last year my organization had done a study of some subset of cases that were litigated before various consumer fora, right from the district to the national level, looking at medical negligence. And medical negligence, again, is a placeholder term for a wide variety of different kinds of harms that can occur at a healthcare establishment. And this could include and has included in the past things like poor infrastructure at a hospital. Now, that I would submit is a kind of matter that is better suited to, in the case of the public sector, public health governance, and in the private sector, it is a matter that is better left to healthcare regulation. So, there may be cases, of course, when that kind of, poor infrastructure. We're already seeing a shocking example of that in our national headlines today with the Jhansi hospital, leads to actual harm and death. But in most cases, that should not be conflated with medical negligence. And until we have a more robust regulatory system that is able to provide an effective method of redressal and actually get hospitals to take these kinds of infractions more seriously, we will continue to see consumer courts being used as a way to find because they've proved to be a more convenient and effective way to find justice for these kinds of wrongs. But the idea is that we should again be thinking about what are some of the regulatory innovations that we can make. And again, some of this it shouldn't always include suspending a license or canceling a license. Again, drawing from models of regulation in the UK and the US, there are ways in which to issue improvement notices to hospitals, get them to submit a plan for how they intend to correct this kind of action. You can decide to have certain hospitals on a more frequently targeted list for inspections. There are different ways in which to make regulation more effective, and I feel like we need to have a conversation around that. And finally, and just drawing on the comment, I think in the first presentation that was made, we've seen a spate of different kinds of, right to health legislation. I mean, most prominently in Rajasthan, where the idea was to have a grievance redressal mechanism. Now, of course, the act itself has been aborted, and there were no rules framed under it, but it did make some bare bones mention of having a more effective grievance redressal mechanism, which would begin with an in-house complaint mechanism, and that would move all the way up towards something at the state level. Again, as I said, the details were unclear. But I feel if we are, again, to reduce the burden on consumer court cases, again, to actually allow only complex questions of law and medicine to be determined by a judicial body, then we need to have a way of triaging cases that actually don't need to go to that kind of judicial or quasi-judicial body. And that begins by thinking about what it means to have an effective grievance redressal mechanism at a hospital. And I think this again means different things in the public sector and the private sector. And I mean, I don't currently have any answers myself, but I would love to hear more from the group here, as well as, think or encourage them to think more about how we can think about a more effective complaints mechanism and how we can make that operational. I mean, again, there are models from Scandinavian countries as far as healthcare ombudsman or patients' rights ombudsmen go, but I'm hesitant to say that that's something that should be adopted automatically, because obviously our our contexts are completely different. But again, something worth thinking about. I feel like the need is ripe for thinking about grievance redressal in a more effective way. And I hope that this convention is a start to having that kind of conversation. And sorry, the last bit, I know I said I would make 3 points, but just as far as the bit on medical tribunals themselves go, I mean, I feel like, again, data shows that tribunals don't end up being faster or more effective solutions. Certainly, they are more specialized solutions, and we can see that that's a problem with consumer courts, which don't have the expertise to deal with these complex questions. But I'm not sure that a tribunal is the way to go, and I'd actually be more in favor, perhaps, of seeing the most complex questions that are unable to be resolved at lower levels actually perhaps go to a specialized medical bench at a high court, because that is what judges are trained to do. We can have judges with expertise in medical law forming in the UK, you used to have family benches as well in courts over there. I mean, of course, they have specialized family courts that deal with this kind of thing. But I feel like going back to the basics and allowing high courts to deal with cases that they are actually meant to deal with might be, we might see a more satisfactory resolution of the kinds of issues that we've been discussing. So I will stop right there.
Thank you very much, Dr. Mehta. Thank you very much. And appreciate the finer points you've made. And let's see how all of this culminates when we're writing out the sort of the points that each one of us has made. I now invite our esteemed academicians from the legal fraternity. I have with me Dr. Sapna Chadda, who is an associate professor, constitutional and administrative law at the Indian Institute of Public Health, Delhi. She's associated with the working of integrated grievance redressal mechanism. Dr. Chadda, over to you, ma'am. Your point of view, you're an expert in constitutional and administrative law. How do you feel we can come out of this and still ensure that nationally we have a sound mechanism for dealing with medical negligence cases?
Thank you very much, Dr. Parag. And it was really eye-opener to hear the doctors. We have been working for the consumers through our Center for Consumer Studies. And as you have said, I am from the legal background, had an opportunity to look into the medical negligence cases and how the things go about. Firstly, my question to the doctors who are here and IMA, other specialized bodies is, hasn't the profession really been over-commercialized? If you look at the international reports also, why I have to go to the private hospitals? I hold this government responsible for that. I also equally hold the doctors responsible for that. If you look at the primary healthcare centers, why the doctors are not ready to go and serve there initially for certain periods? Why so much of backlash against that? And what the state governments are doing for that is because the doctors are not available, they are coming out with certain specialized courses where they are putting paramedics who can deal with certain kind of basic problems that patients have. Are we not encouraging quackery through this? Firstly, it is the responsibility of, I think, the state government to look into these issues. They have to really go ahead and make the public healthcare system more robust. And so that I need not have to resort to the more costlier systems which are there as far as the consumer is concerned. Second thing, as Advocate Bajpayee has also hinted, the trust of the consumers is eroding. You are saying more and more medical negligence cases are going to consumer forum, but if you look at the population we have 140 crore people, all of whom are consumers, and all of whom at one point or the other they are the consumer of healthcare services. I am from a legal background. I can always avoid going to a lawyer. If I have some kind of rift with someone, I can go for out of court settlement, but doctor is one profession which I cannot avoid whatever I think. It is my choice. I go to the allopathic system or Ayurvedic system, but doctor is a must. So look from the point of the patient. You are saying you are going for a defensive treatment, but are all the consumers going for medical negligence cases? No. It is handful of people who are, whether we talk about the consumer forums or we talk about the civil courts, only handful of people are aware. They have the resources, they have the means to approach the consumer forums or the civil courts. So, but I am, as a consumer, made to bear the cost of that litigation. When you say it is defensive medication, defensive treatment, I am made to bear the cost of it. Is it justified? Is it ethical? Doesn't IMA need to look into these aspects? Aren't one kind of test or diagnostic treatments should come at what point of treatment should be mandated by IMA? This is one aspect. Then I agree, the Consumer Protection Act was enacted with some kind of view that it has to be an area kind of a thing where both the parties will come, the bench will hear both the sides. It has to become some kind of a summary procedure, 1 or 2 hearings, and the matter will be resolved in it. That didn't happen. So a second, after almost 3 decades of the earlier act, we tried to refine the act, went for some kind of an adjustment in between, tried to give some kind of a time limit, 3 months, 5 months, 6 months on an average for redressal. That did not happen. I agree there are problems with the consumer commissions which need to be rectified. Delay is there. Dependencies are there. There are different reasons for that. We need to look into those and we need to rectify the system. But when we are talking about an alternative, we are saying go for an alternative. I'm not averse to saying that we can't have a specialized body for it. We can always have a specialized body for it. We are having for a number of service sectors. We are having for banking. We are having for insurance. We are having for a number of services, specialized tribunals. But if you look at those tribunals, still 85% of the service sectors complaints which are going to the Consumer Commission, 85% of those are from service sector. Though we have banking ombudsman, majority of the complaints are still going to the Consumer Commission. Can you ensure that if you have a medical tribunal, complaints will not go to the consumer commissions? The options you are providing is that we have to just bar the jurisdiction of consumer commissions. That the Supreme Court has already said it's an additional forum. You have to give choices to the consumer also. Let him decide where he wants to go. Even if you are proposing, let's have a medical tribunal, go for it, but give a choice to the consumer. If you have an efficiency in the alternative mechanism, people will automatically go there. They will not go to Consumer Commission for their redressal. But we need to understand that when one system fails, instead of rectifying that system, we start proposing for an alternative system. As Professor Suresh has already pointed out, that we are already having a plethora of laws and bodies, not only for the not only for the medical profession, but for all the professions which are being governed. Do you really want to have an additional litigating forum for you? Because when you propose it, neither the parliament nor the government will agree to bar the jurisdiction of consumer commission unless and until the Supreme Court agrees to it, which has already been to a certain extent disagreed by the Supreme Court. I am of the view that all professionals, whether they are lawyers or doctors or any other profession, should be under CP Act. And if we are talking about MK Gandhi, we should talk about reviewing MK Gandhi from other perspective. There is a need for the review of MK Gandhi by the Supreme Court of India, not from the perspective of excluding other professions, but is it really justified to exclude legal profession? As has already been pointed out by experts earlier, that legal profession has all the time to look into things beforehand, and if there is negligence by them, that also should be under CP Act. I am of the view that. And secondly, when you're talking about frivolous complaints, see, the earlier act clearly said if there's a frivolous complaint, the penalty will be there to even the consumer. Now, in the second act, inadvertently, that was left out, but that has been taken care of by the government under the rules. So they say if the frivolous complaint is there, the Consumer Commission can always take cognizance of that. So, if the frivolous complaint is there, the commission is there, headed by a person who is heading the district, who is district judge or a higher judge, to take care of that thing, and that will be taken care of. If you look at the kind of medical negligence cases which are going to, they are of grave nature, mostly which involve a death, or a perspective in which the person is in such a position that he is not able to lead his proper life henceforth. I don't think petty matters or small medical negligence cases are going for the Consumer Commission as such. Neither the public in India is so educated or aware that they go for small matters before the consumer commissions. Litigation in India is still a very harsh reality for any family, whether you are litigating in consumer commission or any other court. So unless and until a patient is really grievously hurt or it is a matter of death, people don't go to any of the forums in India. That is my view. Then coming up, I completely agree with Advocate Bajpai when he says that the mediation should be open for even medical negligence cases. It's a win-win situation for both the sides. I was part of the rules when it were formulated, mediation rules under the Consumer Protection Act. And there were two views which were expressed. We were of the opinion that all kind of cases, consumer cases, should be open for mediation. But the other side had a view that keeping in view the consumer's bargaining power, is not that large that he can really go for an out-of-court settlement. And secondly, when we are talking about grievous hurt and death, there are certain times even criminal aspects are also associated. Criminal cases are also there. So at the first level, they decided to keep these kind of cases away from the mediation process. But I am of the view that the government really needs to think about that there is need for exclusion of medical negligence cases as far as the these mediation rules are concerned, and because these are rules, they can always be modified at the government level, and the inclusion of medical negligence can be made. If it is done, it is definitely a win-win situation for both the sides. And they are also required to augment the mediation infrastructure. they really need to activate the mediation, which is a very infant stage at present times as far as the consumer commissions are concerned. Another thing I'd like to say about is internal grievance redressal mechanism which the hospitals are having. Now, if you look at the kind of tribunals or the ombudsman we are having, like we have a banking ombudsman, if you look at, it has integrated the internal grievance redressal, which they call as nodal officers at the bank level. So unless and until the complaint is rejected by the nodal officer of the bank, that doesn't come to the banking ombudsman. Why the hospitals are not having a robust internal grievance mechanism? If my grievance gets redressed, I am heard at internal level itself, the complaint will not go. At least I can say more than 50% of the complaints will not go.
Dr. Chadha, can you wind up, please? Yeah,
yes, surely, sir. Few more things I'll just point out. One is the expert evidence. I'm of the view prima facie telling the consumer to come out with an expert evidence becomes really difficult. We also need to look into the record keeping and the training of doctors, paramedics, consumer awareness also, so that they're also aware whether it is actually medical negligence or not. And finally, the compensation. Something we leave for the courts also to decide, with the Supreme Court coming with so many things. Courts are the best judge to decide about the compensation. And thank you very much, Dr.
Thank you. Dr. Utture, I will come back to you in your second round. I can understand some of the comments you'd like to make, but let's not forget, ladies and gentlemen, that with the Bharatiya Nyaya Hit Samhita coming in, section 106 is considered by doctors, I repeat, to be quite draconian. The understanding that I think there is a Supreme Court judgment which starts off with only saying that doctors are not God. So let's keep that in mind as we move to our next panelist. I have with me Dr. Sushila. Dr. Sushila is an associate professor of law at NLU Delhi. She is heading the chair on consumer law established by the Ministry of Consumer Affairs, Government of India. She's been a member of the law drafting committee under the new Consumer Protection Bill 2019 and currently working as member on various committees to review the current laws constituted by the GOI. Dr. Sushila, I just heard Dr. Chadha talk about the fact that lawyers should also come under Consumer Protection Act, which is not currently the case. Input to you probably as you are looking at reviewing the laws, that you have a lawyer who is teaching constitutional law to put lawyers also under Consumer Protection Act. I don't know about doctors getting out of the Consumer Protection Act, but I guess with strong opinions like these, we will definitely ensure that lawyers get back into it or will get into it ab initio. Dr. Sushila, over to you for your point of view on this matter.
Thank you very much, Dr. Parag, and thank you for inviting me for this convention, which is a high-level discussion. Thank you. So I just want to give a brief background of how the thing started for the people who are not from this area. So Consumer Protection Act 1986 was passed, and all type of services and goods were covered under this. And the definition of consumer and services were very wide. And there is a section 1.4 which is still kept in 2019 Act. It is giving a very wide definition, very wide meaning to the services, and all type of goods, all type of services are covered. And the definitions are also very wide, and the whatever type of confusion was there, that was also set at rest by different judicial pronouncements, including Lucknow Development Authority, which is a very wide judgment, which includes even statutory authorities which are giving any services for consideration, like DDA or Lucknow Development Authority, to be under consumer law scanner. And also then you had IMA versus Shanta, which has been discussed by various panelists, which has set at rest the conflict opinions which were there at the lower courts, lower fora level. That whether consumer is a service, is a consumer, patient is a consumer, or doctor is a service provider or not. This was set at rest, and the arguments that this is a profession, not a business, and they are governed by professional ethics. That is all. That was not accepted, and it was also not accepted that by the Supreme Court ultimately, that they are under contract of personal service, which was the reason for keeping the lawyers out of the scanner of consumer law. But that is also a doubtful. I think that is not a final judgment, and I think I have hope that that will be reconsidered, because the amicus curiae, I have my opinion also. I support and I agree with the amicus views on this, and Dr. Sapna has also talked about that. So it's so all that. So after all discussion, it was decided by the Supreme Court that doctors and all other professionals are under conjugal law. Now it is also discussed by Justice Tripathi. He had also talked about that medical professionals should not be under any fear of undue treatment by the judiciary or law, because it is international jurisprudence that there is a policy consideration in favor of the doctors. When you talk about criminal law, there is no judgment against the doctors, except one case which is cited by J.K. Matthew, Jugan Khan. But that was the case of some other field doctor using medicine which is prescribed in allopathy in combination with Ayurvedic medicine, Dhatura, which was not permitted because he was a practicing allopath. So allopathic, not allopathic, but homeopath. So that was another matter. But except that case, we don't find any criminal law case, criminal penalty against doctors. So we can say fairly that under criminal law, there is a protection to doctors, and medical professionals have been favored in the sense. So the grievance should be the other way around. The other side should be having grievance as far as the pro medical professionals' approach of judiciary is concerned. It may be the other way around, but we also understand that doctors don't have time for being in the court and defending themselves. That is also understandable. So various points are cited, and in the concept note also various alternatives we are talking about. We are discussing alternatives to consumer courts. We accept that, as Dr. Sapna has also said, that there are some flaws in the present system of consumer law. But however, there are various important points in favor of the present system of consumer commissions. Firstly, it is not a court; it is just a commission, which has in its composition people from different backgrounds, including social sciences, and at NCTRC level, National Commissioner level, we also had a doctor for 8 years. He was at panel, so he was a doctor member. Similar type of what is my suggestion? Ultimately, I wanted to talk for more time, but we don't have time. So at every level, my suggestion is that every level, district, state, and national level, they should be looking at the data available. We can appoint a doctor at every panel where there are more number of consumer cases against doctors. So if this can be done, so we can overhaul and make we can strengthen the existing system instead of having another system or finding alternatives. Because in alternative system, they look very attractive. This is very important to understand that they look attractive, but these alternatives are from other countries, from other jurisdictions which are already working in a very fine manner as far as their tort law jurisprudence is concerned. Indian tort law jurisprudence is not developed. We have seen in various cases, and sorry, picture we cut. Every time there is a discussion over Indian tort system, we are failing. So at least we had something as improvement over the judicial civil law system of India, which is consumer law system. So in consumer law system, if any changes, if any overhaul or the system can be improved, that should be done by us instead of going for another system. And motor vehicles legislation has been very important improvement over civil cases of accident. And as far as criminal law penalty and criminal punishment against doctors is concerned, as you have Dr. Parag Rindani sir have pointed out, the amendment, the BNS 5 lakhs so that you can say that there is some you can say accountability, but accountability we all should feel accountable, and this is not bad, and discipline in all sectors is very important. But as far as medical tribunal is concerned, if we are considering that also, the composition of medical tribunal should be such that there should be proper representation of all sectors, all people, including consumer activists who are working in the field of patients, and it should be headed by a medical professional. It should be headed by a legal professional, in fact, which who have been handling these type of cases, medical legal cases, who have experience in working these areas. So this is from my side, and Justice Tripathi, I agree with his points when he says that we have been doctor friendly. We have been having a doctor friendly approach, and we also, if we see medical jurisprudence of India, we see that Bolen test is still applicable in India. We have not gone to apply the new test, which is already in prevalence in other countries, Bolitho test. We are still stuck with Bolen test, which is more sector friendly, more medical professionals friendly. And there is a policy consideration of all the systems that doctors are protected. Doctors should not have any fear of litigation. And this is, I think, I will humbly disagree with you when you say that Indian people, Indian consumers are over litigious. This is a similar type of argument which British Indian government had given when the draft tort bill was being codified, and there was a effort to codify Indian tort law. Though there was CPC, but CPC only gives power, but tort act could not be passed in India. Similarly, if we have got something very important, some important remedy, consumer remedy we have received, that should not be done away with these defensive medicine reasons and other reasons. These will always be there in the alternatives also.
Thank you very much, Dr. Sushila. Chris points. I'm just moved by the entire argument, and I'm sure I speak on behalf of all doctors across our huge and expansive country when I say that if you're going to be so greatly friendly to doctors, I'm sure you will be equally friendly to your own fraternity. And probably I will here put 5 votes on Dr. Chadda's point that probably it's time that lawyers also move in. But we are not debating that. We are debating alternative methods. And now I'd like to, I have 2 more voices which need to be heard, and both are extremely important and pertinent voices. One is the voice of customer, and the other is the voice of the existing government in terms of the Ministry of Law. So before I go ahead, I'd like to first of all invite, and I think we have adequate time, I'd like to invite Mr. Muralidharan YG, who has, one second, just let me get... who's been involved in consumer advocacy since 1993, a founder of Consumer Rights Education and Awareness Trust, a consumer advocacy group way back in 1993, published more than 5,000 articles and 45 books on consumer protection, right to information. He was a former member of the Central Consumer Protection Council, a former member of several working groups with the GOI, and a guest speaker at the National Law School Institute, of this university, Fiscal Policy Institute, Administrative Technical Institute, and has formed the Voluntary Consumer Action Network, a state-level network of consumer advocates. Let's listen to the voice of customer. Over to you.
Hello? Am I audible, sir?
Yes, you're audible, sir.
Okay. Good morning for all the participants here. And let me thank the Gujarat National University and the Law of Medicine for giving this opportunity. I would like to start with a small, this one. The Institute of Law and Medicine, the tagline is value-driven and evidence-based. That is the tagline that has been used. I think that is the main way in which we need to go to this discussion. We have heard enough about the drawbacks of the profession, that medical profession coming under the Consumer Protection Act. Right from 1991, when this UP Shanta judgment came, we have been hearing about this, criticisms or the problem that is being faced by the professionals, that is the medical professionals under the Consumer Protection Act. So, for example, some of the earlier speakers have flagged that there is no rules for fixing compensation. There is delay in giving judgments. There is some frivolous cases have been filed. There is the doctor's goodwill has been defamed. And of course, the composition of these consumer commissions doesn't have an expert, and all these things have been flagged. This has been in discussion for so many years, not now. And coming to the today's discussion, the paper, that briefing paper, has some 7 issues flagged. So I would like to restrict only to 2, 3, because some of them have already been answered. Now, before going to have a separate mechanism for consumer grievances as far as medical negligence is concerned, we need to see what is the drawback of what is the problem with the present Consumer Protection Act, particularly the 2019 Act. One, if you see the judgment of VP Shanta, it has been very clear that professionals are to be covered under the Consumer Protection Act, particularly the medical professionals. And the recent judgment, which has already been overruled or given by the Supreme Court, that it cannot be reviewed, the Gandhi judgment case. So there the matter stands. So legally it is fine. Now the question is, how effective will be the alternative methods that is being flagged now, in the sense, whether it is Mexican model or the Netherlands model or the Denmark model, how far it will be effective, or what is the alternative mechanism that we have in India, how are they working? In fact, my friend Professor Chadda has already mentioned about the drawbacks of the system it's available, whether it is Indian Medical Council or the National Medical Commission. All these things are there, but how far they are actively working? How many of the consumers' complaints they have solved? How many consumers have been benefited for that one? This is one issue. The second is, they want to go for a tribunal type of system. That's what the paper says. Now, consider the other tribunals that is working in India. Are they working? Whether it is electricity tribunal, whether it is a tax tribunal, anything for that matter, are they working properly? Have they given solace to the consumers or the litigants? Now, how at all another tribunal will come, and as far as the medical profession is concerned, how at all will it work? And Chadda was giving a very good example of the banking ombudsman scheme or the insurance ombudsman scheme. I know medical profession is not equal to insurance grievances or banking grievances, but definitely we need a cheaper, quicker remedy for the consumer. That was the objective of Consumer Protection Act. Even right now, that is the objective. So there needs to be something strengthening of the existing mechanism, and then see how this works or not, then go to the alternative system of redressal mechanism. I don't think the various models in the country that has been presented here will work for India. There is a lot of things. Now, let us not go into the whole health sector as such to bring out those points. As far as consumer issues only is concerned, let's see now. For example, how many consumer cases or the medical negligent cases have gone in favor of doctors or in favor of consumers? Long back when the VP Shanta judgment came, after that a year afterward, the Voluntary Health Association of India made a study. 95 to 90% of the medical negligent cases have gone against the consumers who have filed the complaint, because there was nothing in that, no material in that. So doctors were left free because there was no case at all, there was no evidence at all. So why it is once again these things are coming up? The second thing is, somebody asked in this session there is no professionals or experts in the consumer commission, and that is the president or the members and all those things. This has also been raised almost periodically. Is there any professional to deal with cricket in Supreme Court? How did the Supreme Court decide the cricket cases, or how do they do some property cases? Anything for that matter. So similarly, there is a competence among the people for going to the as members of the commission or the president of the commission. I would like to raise one question which has not been discussed so far. 2005, the Supreme Court gave a judgment in the Jacob Matthew versus State of Punjab. There, all the issues which has been raised in today's meeting has been discussed in threadbare in that case. Further, the Supreme Court has also given certain guidelines to ward off all the confusion that between the professionals, that is medical professionals, and the Consumer Protection Act. For example, they say that there are given certain rules only. Now, the only way which we can do or which means make it effective is to go for some rules that can be drafted based on the guidelines given by the Supreme Court in that particular case. Okay, maybe for example, they say the expert opinion to be to be taken before a case is heard or before a case is maintainable or not is to be decided. So why not to do that one? Why not there be an expert committee? Unfortunately, what is happening is, even for consumers, we don't have any doctor coming forward and telling that there is something has gone wrong or not. If an expert committee says, no, there is no case at all in this, definitely no consumer will go. That is the idea. But unfortunately, the cooperation between the medical professionals and the consumer groups or the consumers is missing. One. The second thing is the Indian Medical Association or the Indian Medical Council, that needs to be strengthened. So here itself you see now how many doctors are presenting their views, how many consumer activists are presenting their views. Here itself we find that imbalance is there. So similarly, the imbalance is there right from all the quasi-judicial bodies are related to medical negligence or medical ethics. So I think instead of going for a different model, different setup or a different system or a different law, we need to look into the Consumer Protection Act. If there is any loopholes, definitely there are loopholes are there, that needs to be plugged and made it more effective. In fact, this will help the doctors also. For example, somebody was telling in this session that cases are delaying over. Yes, there is delay. Why there is delay? Again, there is a professional coming there, like the legal professional is coming. He is asking for adjournment, not the consumer is asking for adjournment. Of course, medical negligent cases take some time. It may not be decided within 90 days or 60 days. Agreed. Because there is some problem, some critical analysis is to be done. For that, we should give some cushion. So what I would suggest is, we would look into or we would go back to the Jacob Matthew case versus State of Punjab case and see what are the guidelines given by the Supreme Court and frame rules accordingly. This is one thing. Second thing is, there is hardly any case at the district level in the consumer commissions against medical negligence. Only from the state level it starts to the national level. So whether there is some redressal mechanism. Now, for example, now at the district level, can Indian Medical Association or Indian Medical Council can do something for this? This is one way of looking at the redressal mechanism, strengthening the redressal mechanism. Then there is also frame, for example, Clinical Establishment Registration Regulating Act is there. Like Mr. Suresh from NIMAM said, there are so many laws are there. Unfortunately, that are not being implemented properly. If that is so, I think Consumer Protection Act will not be a sort of tiger for medical professionals. And also there is one clause in the Consumer Protection Act. This is in this is an alternative method for redressal of grievances. That is in act in derogation or something like that. There is a clause is there. So a consumer can go anywhere. A doctor can go anywhere. So that sort of freedom is available. That is what value-based and evidence-based is concerned. One. Indian medical councils are there. There is one. Can medical councils, other statutory body, be refurbished to be more effective? This is one thing. How many consumer representatives are there in Indian medical councils? Only doctors should decide whether there is medical negligence or not. Okay. Consumer has to have a say. I have not seen anybody, any consumer groups or consumer activists or consumer lawyers representing in those bodies. Similarly, the for compensation also, I agree there should be some rules under the Consumer Protection Act also. Even medicine, there are certain cases where compensation has not been given at all. So I think the Consumer Protection Act per se is very much required and not to be disturbed, and medical profession is to be brought in and it should not be excluded, provided the concern of the medical professionals like compensation or defamation or delay, that needs to be taken into account. Maybe there should be a separate bench like for dealing with medical negligence cases within the Consumer Protection Commissions Act, because that requires a special treatment. So something like, now we have courts to decide, special courts to decide politicians or the people's representatives courts, something like that. A separate mechanism can be done where medical professions can be, cases can be decided quickly and taken some expertise also. So I think these are all some of the things. Instead of going through the thorough overdoing or overhauling the Consumer Protection Act, some small gaps are there that needs to be filled. So I think similarly, I think legal profession also needs to be brought into Consumer Protection Act. There may be some review that we don't know. Of course, let us see how best these things are being thrashed out.
Thank you so much. Thank you, Mr. Muralidharan. And just one rejoinder to what you said. I'm not opining, but I think the choice of the who is going to be more the doctors versus lawyers versus academicians was made by the organizers. So I probably, that's something which we really can't opine on today. Anyway, I'm going to pass on to my last but extremely well placed to opine on policy. I'm going to come on to Madam. She's been waiting patiently for a long time. Dr. Mukulita Vijayvargiya, Additional Secretary, Ministry of Law and Justice, Government of India. Madam, you are in the ministry. You've heard the doctors, you've heard the lawyers, you've heard the academicians. Your point of view, ma'am, about where do you think this should finally end up? Dr. Mukulita, ma'am.
Thank you, Mr. Agrandanji. I thank GNLU and the Institute of Medical and Law to organize this National Commission on this very emerging topic.
I'm sorry to interrupt you, but your voice is coming across as extremely feeble. May I ask you to kind of either speak a little louder, or maybe the voice on your mic needs to be enhanced? My apologies for interrupting you, ma'am.
Good afternoon, everybody, and especially the law persons and the academicians and doctors. And this is an emerging topic. I think, am I audible now?
Slightly better, ma'am, but not really.
So this convention is a kind of an exercise to review the mechanism laid down to address the grievances of stakeholders in this sector under the NMC Act of 2009. I appreciate the efforts of GNLU students, faculty, and also of the Indian Institute of Law and Medicine to have done a study of different systems in other countries. But in this context, I just wanted to start with our slogan, which every Indian knows: Pratham Sukh Nirogi Kaya, Duja Sukh Ghar Mein Maya. Pratham Sukh Nirogi Kaya. And for this Nirogi Kaya, doctors are available and doctors do their best. They make their best endeavor to treat you, to redress your grievances physically, whatever you are having. They give you prescription, they give you advice, and they affect your, by negligence, they affect your health, I should say human life, not the human rights. Human rights are always available, but medical negligence affects human life. And that is the cause of concern of this convention. In this convention also, there should be any mechanism to protect the doctors from penalties which they are to pay or to pay under the act. But here my viewpoint is different. Treatment is different, but there are two factors before treatment, and those are due diligence and manviya samvedna. You will not commit medical negligence if you are a person of integrity and a person having human compassion. You are compassionate and you are sincere. That's why you will adopt due diligence. Standards may not be uniform because we have heterogeneous society and we have a big difference, a radical difference in the infrastructure facilities in urban and rural areas. So what kind of standards? Standards of equipments, standards of services. Yes, we can maintain standard of services in both the areas, but as far as standards of equipment are concerned, some equipments are not available in the rural areas, and that's why the medical negligence is committed. And medical negligence is committed not only because of the doctor, but because of the paramedics or the nursing staff also. Who is liable for it? Only doctor. What about nursing staff? Because they are the persons who take care of the post-operative care taken by the nurses. Pre, also nurses. So here doctors are sometimes not negligent, but we have to realize the fact that, or we know that, every doctor knows that, every consumer knows that, there has been a commercialization, I think within 2 decades of this, after independence, past 2 decades, we know that there is a commercialization. And because of this commercialization of private hospitals, of the doctors, the organ, transplantation, everybody knows the cases of these things. And what is that? Whether that will come under the medical negligence or deliberate criminal negligence, I should say. So civil negligence, that is sought, and the medical negligence, deliberately done, that is a criminal negligence. Here we find that the law comes into picture and law regulates everything. Law is a bundle of norms which regulates human behavior, including the behavior of the professionals, maybe the lawyer, maybe the doctor. So now let us come to the point how to eliminate this mischief. Because law is a bundle of norms, either to regulate the behavior or to eliminate the mischief which has emerged from the existing law. We have a statutory history of 200 years. Certainly now the laws which are coming, they are replacing the earlier laws for eliminating the mischief. In case of doctors, I consider due diligence should be the priority. Regular programs of internal 3 years, 3 years at the interval of 3 years, regular programs for refresher courses like you have in the schools. Similarly, regular programs on medical negligence or preventing medical negligence for all doctors should be there. Standards to be reviewed in view of critical cases, and those are to be updated and to be uploaded. And there has to be a manual of standards for each and every disease where each doctor needs to observe it, and if he doesn't observe it, then it's medical negligence, and we can mechanically punish or penalize the person who is responsible, maybe a nursing staff or maybe the doctor or maybe the hospital one. Doctors are to be updated with the new researches of medical cares of different countries that is available. Why don't we have an all India or global tour of all those? Global tour doesn't mean that physically one has to go, but at least we have to study what is the global medical care in different countries and what we can adopt. India is a very different country with different food habits, with a different living style causing number of diseases. So we have to see that heterogeneous character, and that law can be adopted. Instead of adopting laws of other countries, let us evolve, innovate our own system, strengthen our own system. Because India is a very different country from in other countries, the society is disciplined. We don't have that kind of discipline. Society is uniform, having uniform faith, having uniform lifestyle and food habits. We don't have this. So in this context, certainly we have to evolve this thing. As far as screening by the other state is concerned, suggestion was made. It still not be possible because it will raise jurisdictional issues. You can't send one case occurring here in Madhya Pradesh and sending to Rajasthan. That we cannot do it. However, professional ethics and due diligence need to be strengthened. Uniform standards are to be documented, and documents are given to the patient. Why we have seen that number of cases have been lost and the doctors have been left free. Why? It is not that I'm in favor of the doctors to be punished, but because the patient is not having documents with proper documents. So he's unable to prove the negligence. We don't give, when we discharge the patient, do we give full documents? No. I know that only discharge summary is given. Day to day tests are being done, but that test reports are not being availed or not at the time of discharge given to the patient. So documents which you are having, same documents you have to give to the patient so that he has equal, he is at par when he approaches the consumer court, then he also has the same document that the doctor is having, the hospital is having. So to prove the negligence, he doesn't have those documents. Either he will bribe some person there, another evil will occur. So it is the hospital is the custodian. So I think for the hospitals, there should be norms that before discharge of any person, all the documents should be given. Secondly, we have informed consent principle, and it is, I think, going to in many cases, other cases also which are non-legal, informed consent. Without information, you can't do anything. Whether we take some undertaking from the doctor also, that when you will, some medical negligence will happen, we say that something happens, then the doctor and hospital will not be liable if he dies. For operation, I think some kind of undertaking is being taken.
Death on table consent, ma'am. Sorry to interrupt. Yeah.
But do we have that kind of obligation on the doctor also? If he commits medical negligence, he will be liable. If we take that, then there will be no cases. Because he will be liable. He has said so. He has signed so. So naturally, he has to pay as per the schedule which we have made for this disease, this much of, for this disease, this much of compensation. So this can be avoided. And whenever we amend any law or whenever we go for any other alternative, find the principle that every statute has generated litigation. We should not generate litigation by law. Law is meant for regulation, not for litigation. And if we all are disciplined, we all are vigilant, we all are informed, we can prevent litigation, because litigation will take time. And there also then you say that there is injustice. So naturally, alternative method of medical tribunal suggested, it appears to be right, but just I will remind one case of insolvency and bankruptcy where I was a full-time member, and there time-bound disposal of cases. That has achieved the success of insolvency board. Within 6 months, the case needs to be disposed of. Otherwise, we used to levy penalty on the professional, insolvency professional. Similarly, if we had time-bound disposal of the cases, then the establishment of tribunal is fine. If no time-bound disposal, then unnecessarily having another body, burden on the exchequer, another thing, and we don't have a system for public awareness. That is the cause of violation of every law. We don't have that system. And I think Institute of Medicine and Law can undertake the system for undertaking awareness campaign in rural and urban areas so that people are well aware of their rights as far as medical negligence is concerned. And they are not just simple something happens and we go to the court. Going to the court has become luxury. मैंने उस डॉक्टर को ना केस लगा दिया है, बस केस लगाना है, entertain करना है, that is a luxury.
Ma'am, can you wind up, please? Yeah.
So lastly, I will conclude that we need to conduct regular training programs, standards to be documented again for rural and urban areas, and also for documentation for the compensation. They don't leave it to the discretion of the court. At least if it is mechanical, then the cases will be disposed of in a time-bound manner. Time is the essence of justice. Let us raise the voice for disposal of cases within this time of 60 days or 90 days, not more than that. I think that will help the strengthen the country, and we should demand for a social security system so that the payment system or insurance system, if there is social security system, certainly it can resolve this problem to a large extent. Thank you all. Thank you very much.
Thank you, ma'am. Given the time that while we had agreed to speak for 3 and 2 minutes in round 1 and 2, and then we were going to request Justice Ravi Tripathi to wind up. I'm not going to specifically give everybody a minute to rebut, but however, I'm going to go order-wise. I know for a fact that Dr. Utture and Dr. Mukherjee had specifically asked for raising certain points. Let me start with the doctor fraternity. Dr. Gurbir Singh, would you like to say anything? But I'm going to actually cut it off now at 1 minute because I want to give a good 4 minutes, 5 minutes to Justice Tripathi, sir. Dr. Gurbir Singh, anything specific that you'd want to rebut or add?
Yeah.
We have 1 minute each, please.
Rebuttal.
Yeah.
This was a free-for-all, like you said, an open house discussion, and I'm very happy to see the bonhomie amongst the people, and also the courage to have disagreements. That's a brilliant part of today's entire talk, and I'm very happy that there are some contentious points which have come up and which would require some addressing from our end. Being, earlier closer to God and now not so close to God in the eyes. So the trust deficit, as Bajpai also mentioned, we should address all these things. Thank you very much. The Gujarat National University students have done a brilliant, thank you so much.
Dr. Mukherjee, your 1 minute starts now.
Am I audible?
Yes, sir.
Thank you very much. Thanks to the organizers, Advocate Vajpayee and Advocate Ravindra Mangal, and to you. I'll wind up in 30 seconds. I think a system of screening of the complaints is essential. Now, that has to be well thought about, well planned, something that is universally acceptable, but we need to have a formal screening because now huge number we are getting flooded with complaints, many of which are frivolous. I do not think commercialization is something different. I don't think that is directly related to, anything can be done by the consumer courts to decrease commercialization. I don't agree. But a screening system is essential. And number 2, mediation. Greater emphasis on mediation is also essential. These are my only 2 concluding points. Thank you.
Thank you, sir. Dr. Jailal, sir, anything you'd like to add?
Thank you very much for this. An excellent plethora of inputs has come in. But only one point I just want to refute because Madam Sota was saying that there is a lack of doctors in the society. Please understand there is a 120,000 doctors are coming out. It is lack of governance. There are enough doctors. You just for any state, you apply, send an application for a doctor post, one post, there will be 100 doctors will be applying. It is only the posts are not created, not applying. That is the one reason which we want to say. On behalf of the Indian Medical Association, we have enough doctors to supply, but the government is not giving the post. Second thing, I just want to also say that can we charge the charge for the criminal case, consumer cases when we are charging the patient? Madam was saying that there are only few complaints are there, then why every doctor should charge? It can be a one complaint. For that will spoil the entire 20-25 years of reputation a doctor has earned. So that we cannot say that it is a few complaints, few cases, but that is when it comes to one person, that one doctor, that is the end of that is the sole thing. So even if it is a few complaints, that we need to be a little more concerned about that and work on that.
Thank you.
I was so much fascinated by this, all the inputs which has been given. Thank you very much, sir.
Thank you so much, Professor Dr. Jailal. Dr. Utturi, your 1 minute, sir.
Yeah, thank you, Parag. Just a few points I would like to add, which some issues were raised over here. Number one, as Dr. Jailal said, that very few go for litigation. But let me tell you, if we can predict which of our patients are going for litigation, we would be very, very happy. So that, so what today has happened is every patient is looked upon as a litigant because nobody can predict what is going to happen. So how can you differentiate between them? Second number is as far as it speaks for itself, wherein it was said by that 95% of the cases go in the favor of the doctors. So when 95, we are talking about frivolous and we are talking about doctors undergoing all this. So imagine out of 195 doctors have to go from anywhere between 2 years to 10 years through all this litigation process, leaving behind their practice and everything. And that is the reason why we are saying that as far as this consumer protection, there has to be some filter before any case goes to the consumer court. Another aspect was raised was the Clinical Establishment Act. Let me tell you, if you read the whole act, and we are fighting for that, there is no ethical issues which is discussed in the Clinical Establishment Act. It only talks about infrastructure and how the patient should come and go and what should be available to that patient. So all the Clinical Establishment Act, the establishments do not come under ethical, and for which we have been fighting that they should be also brought either under, you bring it under the clinical establishment ethical issues, or you bring it under the national commission is concerned. I agree. This Bolam's test, Bolitho was spoken about. Let me tell you, unfortunately, though Bolitho is not much followed in India, there have been cases where the expert advice of the doctors was not taken by the court. And when it went to the higher court, the state forum or the national forum, they have said that the lower forum has not taken into consideration this expert advice, and therefore we give another judgment. So you can see that these things are happening on practical aspects.
Yes,
and just to last point, just to add to you, Parag, we as doctors have never ever said that lawyers should come under consumer court. We are saying just like how lawyers have brought themselves out of consumer court, we request them to fight with us and get us out of the consumer court.
Excellent. Thank you very much, Dr. Utturi. Professor Suresh, your 1 minute starts now, sir. He's not there? Okay. Okay. Dr. Ravi Shankar, sir.
Yeah, thank you again. Let's go to the history and see when was the medical professional became defensive. It's only after the Consumer Protection Act. So please accept the fact that the defensive practice, because of Consumer Protection Act, we don't know which patient is going to be litigation. What I was taught in the National Law School was Indian society is a litigant society. Be aware of it. Let us, as a professional, have to be aware of it. And if the public health system grows well, why should they come to the private sector? You say they are commercialized. Yes, medical education has already become commercialized. When that has become commercialized, healthcare system delivery also will become commercialized because patient doesn't want it an equality or equity. They want the best in the neighborhood. They want the best. They want the best, they have to pay for it. And that is how it has to be there. I still don't believe much on the screening for the patient because since it is a litigant society, they will want everything to be judged at the highest level, that is the courts. And that is why the screening may not be useful. Now I have to change the word of a medical tribunal to be a medical bench as suggested. I think if a medical bench under the Consumer Protection Act is what I have envisaged as a medical tribunal, if that is so, I think it will be fair enough. Delayed justice is never a justice. That is why I want an early judgment, and that is where a medical bench is needed for it. Thank you for a wonderful opportunity, excellent deliberations. The quality of papers presented from Gujarat Law University was just commendable. Thank you all.
Thank you, Dr. Ravi Shankar, sir. Advocate Bajpai, over to you, sir. Your 1 minute starts now.
So rather, my advice to lawyers is stop attending meetings where doctors are there. Thanks to our Honorable Supreme Court. So fair. And one more comment to make is that doctors have now become very smart. They are just using that judgment passed by the Honorable Supreme Court. Anyway, two aspects, or rather three, on which I'll give comments. Number one, Bolithos test is applicable in India in a number of cases. The honorable courts, although they have not taken the name of Bolitho, but they have applied the principle, which says that expert comment, expert opinion is not sacrosanct. The ultimate arbiter happens to be the court. It is applicable in Indian courts. One. Number two, Mr. Murli, the consumer voice, he was talking about Jacob Matthews case, the 2005 case. It is on criminal laws, not on Consumer Protection Act or the civil laws of this country. So the guidelines which have been framed there are only for criminal cases. And there is a difference between frivolous cases and the cases that are rejected. Frivolous means outrightly frivolous, for which the courts can obviously ask the complainant, the petitioner, the plaintiff to pay a cost. But a case which has some merit, but because of weighing of the probabilities, it has lost, is not a frivolous case. That is all, Parag, from my side. Thank you.
Thank you very much. I move on to Dr. Dhwani Mehta. Any rebuttals, additional points, ma'am? You have a minute, 2 minutes.
No, I don't think I want to. I mean, if I say anything now, I feel like I'll just be recapping what I've already said.
All right.
So you can move on.
Thank you so much, Dr. Mehta. Much appreciated. Dr. Chadda, over to you, ma'am. Your minute starts now.
No rebuttals as such, sir, but one thing I'll like to say. Firstly, we all agree to disagree. That's a basis of good discussion and for reforms in future. But we all should, as different stakeholders, try to make the consumer machinery more effective. It is a win-win situation for all of us. If we can just reduce the delay and pendency, the time of decision making can be reduced, which is the responsibility of all of us, not only the consumer commissions. I belong to legal fraternity. From my end also, from legal fraternity, we all together do it. It will become a very efficient machinery, which both the doctors as well as the patients will appreciate. That's the only thing I would like to say. Thank you.
Thank you, Dr. Chadda. That was a crisp 49 seconds. Ma'am, Dr. Sushila, ma'am, any rebuttals, additions? You have a minute.
Yeah, I just reinforce what I had said, that new alternatives we are trying to find out, but the existing system should be strengthened by us. And whatever mediation, because mediation is very important and mediation is already provided under the consumer law. So the mediation and the consumer centric approach in the tribunals which are suggested now and the no fault schemes may not be required, because we already have mediation scheme under the mediation cells at every every commission. So that is a process which is already known to the Indian consumers, and Indian consumers were made aware by the government by spending too much money on advocacy programs. So if we are providing a new type of system again, and there will be requirement of new advocacy schemes, and I think Indian system is totally different. Indian public is different. Lack of awareness is there, and that is the main problem, due to which I think existing system should be strengthened, because that is we are familiar with. Thank you.
Thank you very much, Dr. Sushila. Dr. Mukulita Vijayvargiya, ma'am, you have a minute for any last minute additions, rebuttals, anything. Ma'am, over to you. Ma'am, we can't hear you. Your mic is muted, ma'am.
Medical negligence affects human life. So it is very important. And considering mediation here, I think it's not proper, because by mediation you are just diluting or compromising, and we are having for this purpose lok adalats. We don't have so many cases to have the lok adalat for medical negligence. And mediation is, I think, that is a process which is adopted in lok adalats. So because it is affecting human life, let us exhaust the procedure which is prescribed under the very Act of 2019, And I think if we strengthen that, that will be fine. Lawyers are analytical nature. They can resolve many cases with the help of the experts. So in every case, in any serious or severe case, we can appoint expert committee to have the opinion, and with that opinion, we can dispose of the cases. So no need of any special alternative mechanism.
All right. Thank you very much, Dr. Mukulita. Before I hand over to Justice Tripathi, sir, for his closing remarks and his overall overarching, views on what's happened today, I think, first of all, I'd like to thank everybody for your very insightful and thought-provoking discussion. Our discussion today on the current legal environment surrounding the medico-legal cases and where it should be under Consumer Protection Act, mediation, other options, was very, very comprehensive. And moving forward, it's going to be essential to keep dialogues open between the legal and medical communities. We need to create a system that at the end of the day, the winner has to be the patient, the consumer, whatever name you give him, वो भारत का नागरिक है और इसलिए हमें उसके rights जो है वो बहुत important होते हैं, and we must never forget that, because these are the people who depend both on the legal as well as the medical fraternity for any sort of recourse. And that's why these are the people we serve, and we must ensure that we bring fairness to the patient. We ensure that even if there is negligence, and whenever there is negligence, of course, we would love to strengthen the system to not have negligence at all. But even if we do, we must ensure that there is efficiency in dealing with medical negligence cases. Thank you once again. And now I'm going to hand over to Justice Ravi Tripathi, who has always been our lighthouse in these matters. Justice Tripathi, sir, over to you, sir. We are all ears.
Good afternoon now. And I can understand that we are late and short of time. But then few comments which I feel that I cannot restrain myself from making. One is that next program when you are taking up, you may now make it little different and say that how best can we improve upon our consumer protection system, or that act which you are feeling like as a tiger. One thing is certain, and everybody has agreed to that, that there is commercialization of the medical profession. And whenever there is a commercialization of a profession, there has to be a regulatory body and regulatory law for that. And that is the Consumer Protection Act. Now, one thing which is recurringly appearing in the discussion is there is delay in disposal of cases. But then the difficulty is that nobody goes to the root of that delay. And that root is our population, our number of judges, and therefore judges case ratio is very poor in compared to other countries where we are talking about that this justice is very quickly given. So that is very important. One has to be careful about that. And second important thing, somebody referred to, I'm not going by name, that there should be there should be no difference in awarding compensation in the matter of a rich patient and a poor patient. Now, this is something very, innovative. This is an age-old system which is prevailing. In motor accident claim cases also, if a person dies of lack of earning means, and if a person dies of higher earning means, there has to be a difference, and that is an accepted position. Unless something more just you are able to suggest that this is how you can govern them. I can understand. So far as non-economic compensation is concerned, pain and suffering to a laborer and to a rich man is going to be the same. But then you say that, no, his loss of income, his loss of earning capacity should also be viewed at the same level or same standard or by same yardstick. That does not appear to be, appealing, and therefore it is to be taken note accordingly. Now, so far as Dr. Suresh referred to number of legislations. See, all those legislations do not apply to all the doctors. They are legislations of different fields. And therefore, doctors practicing in those different fields are governed by those legislation. Now, that way, if you look at our law books are flooded with the number of legislations which are governing the affairs of the people of the country. But then every single person or citizen of the country is not facing those particular laws and those restrictions. It is very nicely said by Dr. Mukulita that she said that law is what? Law is a bundle of norms. And bundle of norms is for what? To regulate the human behavior. So those legislations which are referred to by Dr. Suresh, they are for governing that particular field. And that is not for every doctor that they will be applicable. And one thing is certain, that when you talk about commercialization, its necessary drawbacks or the negative effects are bound to be there, and those negative effects are required to be regulated by law, and that is why we have the Consumer Protection Act. Now, I think instead of comparing the doctors and advocates in the matter of applicability of Consumer Protection Act is not warranted, because you rightly said that we are not, somebody rightly said that we are not arguing or pleading that advocates should be brought under that, or we should be, but possibly its applicability and its harshness, that is required to be taken care of. And that can be taken care by various means. And therefore, I suggest to the organizers that when next time we have any such program, we should have the program on how to improve upon our Consumer Protection Act and its applicability. And one more very important point of focus is that how do we cut the delay in deciding the cases. And for that, we have to look into the infrastructure facilities which are available in other countries where the justice is quick, and in our case where the justice is delayed. See, the difficulty is, it was very rightly said that after, say, 10 years, if you award 1 lakh of rupees to a person, it is of what value? And it's absolutely right. In fact, if you go to the jurisprudence aspect, you will find that even in motor accident claim cases also, it is accepted principle that we cannot compensate the loss of life if it has occurred. And at the same time, we cannot compensate somebody by awarding particular amount for the pain and suffering he has undergone, emotional setback he has suffered. But we don't have any other alternative. Then, therefore, we have evolved the system of compensating the person by amount. So that particular, to my mind, that particular discussion of making a difference or not making a difference in between rich and poor is not very, appealing to me. But let's see if in future anything we are able to evolve better than this. If somebody earning 1 lakh of rupees per month is suffering, say, incapacity to earn, and a person who is not able to earn anything, if he's suffering that incapacity to earn, they cannot be put at par. That is an accepted principle. But anyway, the discussion was very nice. Number of things I have also learned, and I'll keep it in mind whenever it requires to be, conveyed to the people at large. Thank you very much. Jai Hind.
Thank you, Justice Tripathi ji, for that wonderful summing up of this excellent session. And I think we are at the end of the session. And I would invite Dr. Dhania to please offer the vote of thanks to our panelists and to our viewers. Over to you, Dr. Dhania, please.
Thank you, sir. So once again, good afternoon, everyone. So I actually, after listening to this program, I would like to start that we are honored to be a part of such a panel today. And I will assure everyone that we have taken note of the voice of the doctors, the advocates, the policy experts, and also the patient advocates. So we are hopeful that we'll be able to come up with a good policy document under the guidance of Justice Ravi Tripathi, of course, and also the esteemed panelists. So without taking much time, I'll move on to the vote of thanks part. And on behalf of the Institute of Medicine and Law, as well as Gujarat National Law University, I would like to extend our heartfelt thanks to every panelist present today here. I'm not going to take everyone's name, keeping in mind the paucity of time. So we are thankful to each one of you for taking out your time on a Sunday morning and having a wonderful deliberation on the topic for discussion today. Thank you everyone for being there and being very supportive in whatever things that we are planning and coming up with. And I would like to thank all our student research teams for being part of this program and contributing through their research, and also the doctor participants for helping our students in this research. A special mention to Vidisha ma'am for coordinating and also guiding the students for the research. We thank Dr. Parag Rindani for being a wonderful host today and managing the show very well. Thank you so much, sir. Sincere thanks to all our audience for showing interest in our program and taking part in the program. Thanks to the ICT team, knowledge, and the media partners. And last but not the least, thank you, like a special thanks from GNLU to Justice Tripathi and Institute of Law and Medicine for having shown this faith in GNLU and considering us for this collaboration. Thank you, everyone.
Thank you, Dhanya ma'am, for that thanks note. And it was a pleasure connecting and collaborating with you. Thank you, everybody. Have a great day. Bye. With this, we close the session. Jai Hind.
Thank you.